Where it stops, no one knows. We're going headed into the unknown. Na, 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 na.
Good morning, good afternoon, maybe good evening. I don't know if anybody's here that's already in the evening, and there's definitely not anybody here yet that I think is in Tomorrowland. So welcome to Criminality, or welcome back to Criminality. Thank you guys for being here. I wanted to start a little early because this morning, in about 40 minutes, we're going to have the motion to compel, the fourth and fifth motions to compel hearing in the Idaho versus Brian Kohberger case. I think most of you guys are familiar with that. I'm not going to go through the details of the case. If you guys don't know, I have an entire playlist on this case. So make sure you check that out if you're unfamiliar. I also have, I typically recommend this for anybody who's interested in investigative genetic genealogy or anything that goes along with it, or what the difference is between the DNAs on what they test and how they test it. In the playlist for Idaho 4, I have an entire live that explains and breaks down how investigative genetic genealogy works and what parts of DNA they use and how they do it. It's good for any case, because obviously investigative genetic genealogy is an up and coming thing that we're going to see a lot in courtrooms. But I happened to cover it when I was covering the Idaho case, so it's in the Idaho 4 playlist. So I wanted to start early because it's kind of funky with this hearing. Sorry. There was one witness who was unable to be in court today, so they actually had him testify last week. So I wanted to play some of his testimony. Hold on one second, sorry. So I wanted to play some of his testimony because obviously it's going to be important to some of the other things that we're hearing today. So if you guys have already seen that, this might be a repeat, but maybe just a little bit of a refresher. I have watched it already, but like I said, I think that it's important to remember the things he says for some of the other things that we're going to hear today in the hearings that we're going to be watching. Now, for anybody who doesn't know, the Brian Kohberger case has a judge named Judge. Ironic. He does have his own YouTube channel where he streams all of his hearings. They do not stay on the channel, though. If you're familiar with like the Daybell case, Judge Boyce did the same thing. Judge is typically kind of follows Judge Boyce's lead. I mean, they're both in Idaho. I think that he just feels like he has more experience with like the high profile cases and what to do. So they both have their own YouTube channel. So he has his own YouTube channel. It's so everything is done like via these cameras in the courtroom, almost like a Zoom. So the quality is not always the best when it comes to the visual, but we typically can hear everything just fine. So that's kind of the most important. So I'm going to say hi to you guys in chat, and then I'm going to bring up the hearing from last week. We'll just go over a little bit of review from that before the hearing starts for today. So like I said, it kind of all goes together. So what's up, Don? Good afternoon from Indiana. Hi, Bonnie. Delana. Hi, honey. Hi, Jamel. Hi, Yankee Ghost. Allie Blue says 5:15 p.m. in beautiful sunny North Wales. Oh, that's so beautiful. Love that. So it is, see, it's evening. What up, Fiend? Hi, the Royal Wee. Hi, Kyra. Hey, everyone. I was hoping someone I follow was covering this. Cool. Because it's a hearing and not an all-day thing, I always just feel really bad. And maybe over summer break, I know that there's a couple trials that will be taking place. I have no problem streaming the trials. It's just I always feel bad that I can't like commit to all the days or all the times when I have to drop off kids and pick up kids. And so I always just feel bad that I'm not giving you guys everything I have. Like that's, if I can't give you the whole thing, I hate doing it. So hearings are a little different. Obviously they're not nearly as long, but sometimes they can be. Don't get me wrong. I mean, look at Delphi. They wanted to have a 3-day back-to-back just hearings. So what's up? What's up? What's up, Fluffy Bunny? Hi, Ashley. This case is a mess too. I know. I think maybe that's what like brings me to the case. Like I'm like, ooh, these cases are a fucking disaster. Let's look at it. I don't know. BGOG. What's up, Mar? Hi, Ashley. Hey, Shaz. Carla. Veronica. We're going down. Snappy Dragon. Hey, Sarah. Get your Dr. Pepper. I do. I have to crack it open. It's still early, but I'm going to have one anyway. I already had an iced coffee. So hopefully we're good to go. Hey, Teresa. Let me hop back down here. Hey, Kez Chick. Good to see you. Now you have a life. Yeah, sometimes. I mean, it's pretty redundant and repetitive, but you know, it is what it is. And the dogs are already wrestling, so they're like, yeah, no, we're not interested this morning. We want to play. Hi, Francis. What's up, Kayla? Hi, Laura. Yeah, an early one today. Well, I also plan on having a Karen Reed live this afternoon to go over, like, I want to go back to like doing some like the opening statements, just kind of see where we're at now, you know, 5 weeks into this trial and what we started with. So this afternoon, I do plan on having a Karen Reed stream, and hopefully I will have somebody coming up with me to discuss a few things. And then I don't know if we will get by today, but there is a possibility with the deadlines on the motion to disqualify. So we'll see. So I'm like, this may be a 2 to 3 live day. We'll see how it goes. Hey, Dawn. There needs to be a judge now. A judge, a judge. Yeah. Oh, yeah, that's my fave. I love that song. I'm going to have to kick these guys out. Kick the dogs out. Okay. Hey, Scott. Hi, Hybrid. Okay, give me 1 second. You guys, I'm going to boot them from the room so that they're not just wrestling. Okay, so how many of you guys have already watched the hearing that took place last week? They had the one witness because he's unavailable this week to come in, so it's kind of like out of place. But how many people have already seen that? Because I am going to play it again. Hey, Travis. I need new green to drop out somewhere. Hey, Yvonne. I'm so here for this. I'm so behind on this case. Well, the positive is that you're not necessarily too behind, because a lot of the things that are kind of coming out in motions are repetitive. But the hearing last week is not. Hi, Jen Lou. Oh, thank you, Allie Blue. I appreciate that. Okay, let me get this going over here. Missed the last hearing. Okay. But it's also easier to do the early lives when I'm not watching a trial trying to take notes the entire time. This is the defendant's motion to compel. Yes. So we have a hearing coming up in about 35 minutes now, and it's on the defendant's 4th and 5th motions to compel. I think they're at like 13 or 14 at this point. Essentially, Ann Taylor, the defense attorney, is stating, hey, we know you guys have this discovery. There's no way you don't have this discovery based on other things that we're coming across. Like how when we find something that says they figured out XYZ, we know they had to have ABC to be able to get there, but you guys didn't give us A, B, and C. So she's fighting for all these I do have it. Hold on real quick. The written motions. Some of them were filed under seal, so it's hard to say because some of it has to do with the IgG, the investigative genetic genealogy. And then I believe today we're going to be seeing the gentleman that on the stand. I'm not 100%, but I think we're going to be seeing the gentleman on the stand, Cy Ray, who is part of Brian Koberger's alibi. So last week, that's why I said we're going to play this a little. We'll play this bit so that we kind of understand. So this guy just wasn't able to be at the hearing today, and so they had him come last week. Hi, Schmeed. Okay, I've been down a wrong rabbit hole, and you are just what I need to snap me back. So, like I said, a lot of it's really kind of repetitive. She's just fighting, like saying, hey, give me this. He's saying, hey, I don't have that. A big situation with this case is how involved the FBI was in gathering evidence. And if you guys aren't familiar, the FBI has their own set of rules. They don't have to just give everything over from their investigation and say, here, take everything we have. It's mandatory by discovery. That's not how it works. So Bill Thompson, the prosecutor, essentially just keeps saying, like, hey, like, I'm trying to get this stuff from the FBI, but it's not always that easy. Like, they don't want to just give us all this stuff. So if I have it, he's like, if I have it, Ann Taylor has it. I don't know if it's necessarily that Bill Thompson isn't giving it over, or if it, like, there's this disconnect with law enforcement. And that's why I'm going to have you, like, we want to watch this because the investigator, Mowry, who testified last week, I don't want to, I'm not going to do any spoilers, so we'll just play it. But the hearing it's essentially, Ariel's correct. The hearing determined that was kind of a lie. Like, they do have some things that they have had and they did not turn over. So it got pretty spicy, as opposed to kind of the redundancy that we've been seeing. I mean, I know that there are still, like, some spicy things, but not for me. Like, when it comes to, like, it's time to get this trial going. They don't have a trial date set still. Have they tried using the magic word? No, they just don't. They don't. I don't think she does. But so Judge, just to say this before we start, Judge is a very passive person. I mean, I can only see, like, as a parent, he was probably like, you want to have, 20 people over for a sleepover? Okay, as long as I think that you're really good at it and I think you'll be able to handle it. He's just he's very passive, and he reminds me, if you guys watch Bob Motta, who you guys know I love. Bob Motta does this, like, family hug. Judge is the epitome of the family hug to me. If the attorneys start kind of fighting with each other, or even, like, going back and forth, he's like, all right, you guys, let's love each other. I know you guys are all very great at this, and I think that you should just love each other. And how about we hug it out? Like, that's how I see him as a judge. It annoys a lot of people, but he is very fair to both sides, and he's very pro protecting Brian Koberger's rights. And every decision he makes, like, he takes the time to, like, go through, think about it, like, how would this affect this, and how does this affect this? And that's why I said he looks a lot to Judge Boyce, because he's already dealt with these high profile cases and what could, possibly happen. But that is the epitome of Judge to me. So I'm going to just play a snippet of this real quick, and then you guys tell me that you can hear it, and then we'll keep going.
To begin the motions to compel, we have testimony today from Detective.
Okay, so I just want to make sure you guys can hear them. Let me see what Travis said here. This has been a very, very good judge thus far. 1, holds a hearing. Yes. 2, insists that both sides be respectful. Yes. 3, understands constraints, realities of the practice of law on both sides. Yes. 3, listens. Yes. 4, doesn't cut off either side. Yes. 5, no snickering. And then he does have rules. A lot of people just want him to, like, pick up the pace and be like, okay, just make the decisions and stop letting the attorneys make all the decisions. Like, you're the judge, you've got to do it. I like it. He's very fair, unlike Judge Beck. But people are like, you gotta set down some ground rules here, Judge, because, or just the speedy part of everything. Like, you're letting them kind of just control what's happening. Okay, so I just want to make sure the sound is up, because I want you guys to be able to hear this, because what they talk about. This is probably one of the better hearings, and I typically only cover Idaho 4 when it comes to good hearings or good motions at this point. For anybody who doesn't know, I am absolutely respectful of anybody's opinion on any case. You can think he's guilty, you can think he's innocent, you can sit on the fence. You're welcome in the chat no matter what your opinion is on the case. What I don't care for is anybody sharing opinions about each other or talking about your opinions of each other in chat in a poor way. You can love each other. I'm going to do a judge, do a family hug all you want to in chat. But if you have a negative thing to say, the mods will take care of it and it won't stay in the chat. But like I said, your opinion on any case is always welcome, because we may agree on one case and then disagree on another. And I don't choose people that I like to talk to or correspond with based on their opinions of a case. I do it based on the person that they are and that we can actually have a discussion without it being ugly. So that's where that is. So my opinion on Kohberger currently is I do believe they have the right guy. I do believe that they are prosecuting the right guy. I know many people who've been in my chats who are like, Teresa, you have got to dig deeper and look, because we don't think that's the case. We think there's tons of corruption. And people believe this fits more into the like Delphi, Karen Reed type of situation. I'm not there. That doesn't mean you can't be. He does need to put down the hammer. Judge Boyce does a good job of checking his attorneys. Yeah, he's so emotionless. You're just like, do you care? Like, what are you doing here? That's how I feel about Judge Boyce. Also, just an FYI, we are on verdict watch in the Chad Daybell trial. The jury got closing. They had closing arguments yesterday, and the jury is out for deliberation. So at any time, we could get a verdict in the Chad Daybell case. Yeah, the case is going to happen like 5 years from now. Okay, here we go.
Marcie, as the court will recall, he's unavailable on the 30th and 31st, which are the days when we will have the full scope of our motions to compel. So it may feel a little choppy, but we would like to hear from Detective Marcie today, and we call him when it's appropriate.
Okay, just an FYI, I am going to try to speed it up. If it becomes too confusing, I'm not going to like jump to 2 times or anything, but because we have the actual hearing that's scheduled today starting, I don't want to be late for that. But if this is like annoying to anybody, just let me know and I'll slow it back down. I know Andrea Burkhart's doing a great job on the legal analysis behind this case. So if you like to listen to the attorneys, I highly recommend Andrea Burkhart's coverage of Idaho 4. But she hasn't swayed me.
Okay, thank you. Anything preliminary, Mr. Thompson, Ms. Jennings?
Okay.
Is this
great? Detective Marcie, line up. You face the clerk, raise your right hand.
Do you solemnly swear that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
All right, thank you, sir. Go ahead and have a seat there. If you're seated, please state your name and spell your last.
My name is Lawrence Marcie, Mowery.
All right, thank you, sir. Ms. Taylor?
Thank you. Will you tell us how you're employed?
I'm employed with the Moscow Police Department.
What is your role there?
I am a detective.
How long have you worked for Moscow Police Department?
I've worked with Moscow for over 5 years.
Have you been a detective that entire time?
I have.
And prior to that, did you have law enforcement experience?
I do.
How many years total?
Yeah, unfortunately.
Detective Marcie, did you take part in the investigation into the homicides on King Road?
Yes,
And what was your role?
a lot of different things. How to answer that?
Well, I can ask you about a couple of roles, maybe.
Sure.
Do you do any work with cell phones and cell towers?
I have taken training for cell phone analysis.
Was that one of the roles that you played in this investigation? All right. And the other area that I'd like to talk to you about is the collection of videotape evidence or surveillance evidence from around the community. What was your role in that?
So we gathered a lot of data, a lot of USB hard drives that came in. At one point, all of that was given to me so that I could copy it over to a server. So we had it stored back up.
Did you inventory it at that time as you got it in, I guess?
Don't have to say inventory. I used the evidence technician to help me book them individually at the time. Right, so the investigation had the name of it on it. I would label the folder, what it was, and that came from it.
Did you have any role in verifying the content of the surveillance?
No.
I'm going to have a few questions about that, but I want to talk a little bit more about your role with cell phones and cell towers. So let's start there, okay? What training do you have for that role?
So Some time ago, I went through what is a PATC training, which is cellular analysis, and I've also taken classes with CASPIS.
The cellular analysis, is that particular to the device itself, the cell phone device?
No.
That is particular to towers?
To the towers and the providers themselves.
When did you take that training?
Well, the CAST, I believe it was in 2019, and then I also did it again last year.
And the CAS that you took in 2019, that was the ENDICAC, is that right?
That was predominantly again, correct?
And the CAS that you took last year was October of 2023, is that correct?
Yes.
And that was the actual CAS training?
They were both done by actual CAST members. I'm not sure if one was sponsored by the other, but they were both done by FBI CAST members.
And Your Honor, if I can approach.
Yes, thank you.
Detective Mallory, I'm putting in front of you what's labeled as Defendant's Exhibit O, and those are 2 certificates for training. Is that correct?
Yes,
All right. The one that's from 2019, what did that cover?
that covered the use of the CASPIS software.
And what did the one in 2023 cover?
The second.
Your Honor, I move for admission of Defendant's O.
Any objection?
No objection.
Okay, those are exhibit, oh, no objection. Thank you.
Detective Mallory, how many total hours do those certificates represent of CAS training?
I apologize, I didn't look, it was a week long, that was actually a couple of days each time. 2 days a piece of
You
paper.
need this, but
2019 shows 24 hours, 2023 says 16 hours.
Thank you, Detective.
thank you.
Detective, you've written some reports in this case, is that correct?
Yes,
I want to talk about 2 particular reports right now. One is from May the 5th of 2023. Do you recall that report, or should I bring a copy of that to you?
it'd be helpful that I got.
I can definitely do that. Thank you. Let me show it to Ms. Jennings.
We have a jury next door,
Okay.
so you know, that's all about it.
Detective Mallory, does that appear to be your report from May 5th of 2023?
Yes,
And Your Honor would move for admission of defendants P,
That's P,
like Paul?
all right, any objection? Okay, thank you.
Yeah.
Exhibit P is admitted, no objection.
Thank you, Your Honor. Detective Mallory, I do not have a police report for the other one that I want to talk about today. It's one that I received via email today that was written just within the last few days by you, probably. Do you know what report I'm talking about?
yes.
Okay. Now, what I want to understand is we're talking about documents or records or logs that can be created by a CAST-Viz program. The report that you wrote that I received today, when did you learn about those documents that exist according to that report?
The session logs that I found were from yesterday.
Why did you come to find them yesterday?
It's been very good, sir.
Okay. And those are things that existed for quite some time, is that correct?
They did.
And
Okay, so I just want to make sure everybody's on the same page here. He just testified that he turned in a report essentially that day that she had gotten that day from information that he'd had for a long, long time. He had this information. She's been looking for this information, and he never turned it over. That's what's coming out right now, is that he's had it and he never gave it to anybody. Hey, NorCal.
when you wrote about your work with CAST-Viz in May of 2023, did you document those items?
No.
Tell me what you found when you were preparing for the motion to compel today.
I found session logs that were sent to me from the FBI.
All right. And in those session logs, how many files were there?
I remember I think there were 6 or 7 different items inside.
Did you look at the Cast Biz 48-hour file?
I don't remember if I did at the time of reception.
Did you look at it yesterday in preparation for this hearing?
I attempted to.
All right. And how about the Cast Biz full log?
I attempted to yesterday.
I noticed in your report that there were several items that you listed. Were those from these Cast Biz logs that you attempted to look at yesterday?
I'm sorry, I'm gonna have to, you need to speak up a little bit, or just telling me to pick up a little bit.
There were some files that were in the session logs, there were other files that were not.
Well, let's start with the 48-hour. What was contained in there?
There's over 48 hours that was the AT&T records, the original records, and there's a 48-hour session log. I don't know which one they're at.
Let's go with the session log. What was in there?
Appeared to be the AT&T records that possibly were inputted, as well as some JSON files that were probably produced by Customs.
JSON files were produced by Cast Biz. Is that right?
I would assume that I didn't create those files.
What date were they created?
I believe one was in December, the other was in April,
December of what year?
22,
And April of what year?
23.
Could you tell who?
Okay, so once again, so these files that he's just happened to find again that have already been sent to him are from, remember, this crime happened in November of 2022. So he just happens to find these cast folders that were sent to him from the FBI back in December of 2022 and April of 2023. We're in May of 2024.
Created those?
I could not.
How did you get those?
I was provided those via email.
By who?
I made balance of the FBI.
What did you do with those?
I gave them as soon as I realized they were in my possession. I had contacted the prosecutor and gave them.
And that would be just yesterday, is that correct?
Yes.
What did you do with them prior to that time?
They were sent to me. I put them in a folder and I didn't do anything else with them. That's why I forgot them.
Okay, and that was the 48-hour file?
The 48-hour session log, yes.
How about the full file? What was contained in there?
Similar to items to the 48.
What is the full file?
I believe that was the second AT&T return that we got via warrant. I was able to open it to verify it.
That brings up a question for clarification. When you say second warrant return, are you talking about something that relates to Brian Koberger?
Yes, there was 2 warrants that were originally written. One that covered a 48-hour period for the cell phone number, and there was one that was later done for a longer period of time.
And those are what you're referring to as the warrants 1 and warrant 2?
Correct. Okay. 48 and one's for the longer period.
In the report that I just received today, there was reference to a loped bar file. What's that?
It's a file that I received from Agent Balance.
When did you receive that?
Honestly, the modification date for that email, I honestly don't remember. Unfortunately, it was yesterday and I didn't throw this stuff together. So,
Okay. So that was one that you just found yesterday?
yes,
Okay. Did you open that?
I don't recall opening it. If I did, I don't recall doing it.
How about the CDR.xlsx file? Would that, and CDR, what does that stand for?
All detail records,
Did you open that?
I don't remember if I did not.
Did you open it yesterday?
I don't remember. I was looking for it. Once I found them, I was trying to figure out how they came into my presence or in my possession. That's what I started to focus on.
Okay. How about the export.kmz file? When did you find that file?
I found that one yesterday.
Do you know when that came into your possession?
It was some time ago.
Did you open that?
I believe I did on my laptop.
What did that show you?
It showed me different locations and so forth on a map.
Those 3 files that we just talked about, along with the CastViz 48 and the CastViz full, are those copied so that I can have those now?
Yes,
And you referred to emails. How many emails did you find when you were preparing for this hearing?
I believe there was 5.
Are those included for me to have now as well?
Yes.
Thank you. In the report that I received today, there was a reference to drawings.json file. What's that?
It was a JSON file that was inside the casted session.
What does that depict?
It's just data that Cascades would use, I'm guessing, to replot something on the map to actually show locations or other things.
Did you do anything with that file when you found it yesterday?
I did open that file, yes.
Okay. What did that show you when you opened it?
There were references to 2 locations inside.
When you open it, what does it just say, here's 2 references, or what does it show you when you open it?
It's different code, but there is some plain language or plain English, plain text inside of that code that show 2 addresses.
Did you use that file? Well, let me ask this first. That file that contains code, do you use that with the CastBiz program?
I attempted to load the session file in its entirety and it received errors, so I was not able to. That's why I went into the JSON file to see if there was something I could see reference.
Is that file usable?
I'm sure it is somewhere.
What is the restriction for you?
I don't know what restriction is. I don't know what to do with that file outside of if I could possibly bring it into the CastBiz. I tried to pull it in as a combined session log, which is what I was trained to do. So I didn't get that. I didn't pull that file.
Is that file available on a discovery drive for me?
Provided to the prosecutor today.
Thank you. In the report that I just got today, there's a reference to another CastBiz session and some screenshots. What is that about?
Well, you're talking about just the regular 48 hours folder.
I don't know. I'm curious.
So that I provided 2 folders. One was CastBiz and one was my last name of Marcie. That was to differentiate the files that I found that were provided to me and the folder of the files that I used to create this report.
Okay. CastBiz is the files that you found while preparing,
Correct.
and the one that says Marcie is what you used to create your May 3rd report of 2023.
Yes.
Okay. I think I understand that now. In that file, I think your report said you found screenshots dated April 19th of 2023.
Yes.
All right. Does that mean that's the day that you put things into your CastBiz program?
That was the day that I made the screenshots themselves.
Okay. Where are those screenshots now? Are those also included on the drive?
Yes.
Okay. And then your report dated 5/3 says that you were asked to examine the record. So I'm a little confused if you had something that you took screenshots of on 4/19, but on 5/3 you were asked to examine the record. What were you doing on 4/19 or before to get those screenshots?
So I was tasked, the date was May 3rd for the report. It's not the date that I asked them.
Okay. What day were you asked to do?
I cannot remember. I'm gonna guess that it was somewhere around April 19th. Because that's when the screenshots were created.
Okay. Let's talk about that time frame then and what you did. Did you actually use a CastBiz program at that time to create something?
Yes.
The CastBiz program that you used at that time, and we're talking about springtime of 2023, we'll call it April for now, if that's fair. What training had you received by then to do this CastBiz program?
The 2019 training.
Okay. With the CastBiz program, what's the first thing that you did?
Once the program is open, you can drag and drop the CDR records into the program.
CDR means call detail records.
Right.
Did you do just 48-hour records or did you do full records in April of 2023?
I only did 48 hours.
When you put the records in, those are the call detail records and those relate to what?
To the phone that the records were coming back to.
The number you associated with Brian Koberger.
Right.
Okay. After you put those call detail records in, do you have to do anything with cell towers?
Okay, so just for clarification purposes, if you guys, like I said, if you haven't followed the case or you don't really remember, they use Brian Koberger's cell phone, and the information that they had obtained from his locations throughout the PCA. So and they have like little maps that track like where his cell phone goes and so on and so forth. And essentially that's what they're saying. And like Travis just said in chat too, somebody down the line says, hey, I need to know where this came from. And for them to have this info, they have to have done XYZ. So somebody has it. And Bill Thompson, the prosecutor, is like, yeah, we don't have it. If I have it, she has it. I'm not keeping anything from her. And that's why I said at the beginning of this, I don't know if it's necessarily Bill Thompson keeping things, or if it is people like Detective Mowry who just have files that they've just completely ignored. They put them in a folder, and that's all they did with it, and they never did anything else until they had to prepare for this hearing. But mind you, the fourth and fifth motions to compel, and this is by memory, so it might be off, are back in like June of 2023. Like I said, we're on like 13, 14 now at this point in time. So she's been asking for this certain information for a year, essentially.
With the AT&T, no, because the cell tower locations are in the AT&T CDR.
Okay. So you put that record in, the tower locations are already part of the call detail record that you put in.
Yes,
Is that something that you have electronic on your computer and then you open your CastFish program and just import it into the program?
yes, AT&T provides both PDF and text documents of the file, and I use the text document to put into CastFish to have it adjusted.
And when you do that, what gets exported?
Nothing. At that point, nothing is exported or created that I know of.
Can you export the session that you're working on?
You can export session log, yes,
Did you do that?
No.
How did you create screenshots?
by using the built-in Windows snip tool, as well as the built-in Windows game console, or they call it the game bar, which is just accessed by hitting Windows G, that allows you to record your screen.
Are those the only two things you did, is screen clip and screen record?
Yes,
How many times did you use call detail records in CastFish program?
probably a dozen times. I'm not entirely sure.
That was a terrible question. How many times did you use the CastFish program in relation to Brian Koberger's call detail records?
I don't know.
More than once?
I recall doing it for the grand jury because I wasn't the main lead in the call detail records investigation.
I don't understand what that means.
I wasn't the main person looking at those call detail records.
You weren't the main person with the call detail records, but you put them in the CastFish program anyway?
For the grand jury, I was requested.
Okay. What did you rely on in producing those, producing whatever you produced for the grand jury?
What did I produce? As far as the AT&T records,
I want to know what you relied on to do that, to produce something for the grand jury.
I don't understand the question.
Okay. You weren't the main guy with the call detail records or with the CastFish programming. Did I understand that much right?
There was another investigator that was doing it.
Okay. But you end up involved in it somehow in April of 2023, is that right?
That's why I was asked to examine the data to provide that for the grand jury.
Okay. Was that all of your instruction?
What do you mean by that?
Well, you're asked by somebody else who's actually doing this part of the investigation in the case to produce something for the grand jury to use. And I'm
Is that the
curious about
prosecutor?
what you relied on, to get to that point. I want to know all the records you relied on, all of the emails, all of the conversations you relied on to produce this thing that you're not the expert for.
So I wrote
She's like, I want to know all the things that you use to create whatever it is that you created that you're not the actual expert of creating. So what did you actually use? And he's like, I don't understand the question. That cracked me up. She's like, but yeah, you don't understand the question because you literally are just telling me now that you had all these documents from before. If you understood the question, we wouldn't even be having this conversation.
the update for the AT&T records. Received the AT&T records. Those records were also given to another investigator who was the main investigator doing the CDR records. Prosecution then asked me to provide or create some kind of visualization of the call detail records and examine the call detail records for the 4 hours in question.
Just to be really sure, when you talked about writing the 2 warrants for AT&T, we're talking about 2 warrants that relate to Brian Koberger. There were a lot of other warrants. Is that right?
Correct.
Okay.
Yes.
I just want to be really clear on that. You've taken the CAST training, is that right?
Yes.
And you know there's a way to save your session, is that correct?
Yes.
And there's also a way just to hit reset and delete your session. Do you know that part too? And back in April, when you were creating something for the grand jury, you hit reset. Is that right?
Or I just deleted the file out of it. I don't remember if I hit reset or if you can leave an individual this one.
You don't remember which thing you did,
I do.
but you decided to delete what you'd created.
I don't know. I didn't delete anything. I didn't create the session log, so I don't know how I was doing it. You delete the reference of the file in the software, but the file itself is not.
I want to make sure I understand. The record, the AT&T record still exists. You didn't delete that.
Correct.
But the session, when you put that in to the Cast Biz program, and it does its thing with the call detail records, which includes tower references, you either deleted that session or you chose to reset. Did I understand that right?
Didn't create a session log. I don't know how I would delete it. I just removed the reference to the file, the main file from the software at some point. I don't know when I did that.
You don't know when you did that?
Okay, but you can close the software without hitting reset or delete.
And then it would just stay there.
I deleted it.
And you can also export your session if you get interrupted and you want to come back and work on it, right?
Yes,
Okay. Did you do that? You left it up and running at some point and then did something that didn't save it. Is that right?
the session log was never created. Did not create a session log. The CDR records I was dealing with is relatively small. There's no need to do that because I can ingest the files right back into Cascades in a short amount of time.
Your Honor, just for clarity, may I approach? I have another exhibit to show him. I'll give it to you, Your Honor. Thank you. Are you familiar with the document that was handed to you that's marked Defendants W?
Yes,
And have you seen that before?
I have.
Is that something that you were taught from the CAST Users Guide?
I'm sure I was. It's also included in the software that can be readily assessments.
Okay. And Your Honor, we'd move for admission of Defendants W.
Thank you. No objection. Okay, that exhibit W is admitted.
Thank you.
No objection.
In your training, were you also taught from the CAST Field Users Guide?
I believe so.
I'm about ready to switch gears on you and talk a little bit more about videos for a second, but if I can have just one moment, Your Honor.
Sure. You can.
Okay, let's switch gears for just a minute. You, during the course of your work, did you make contact with the Idaho Department of Transportation to talk about some of the cameras that cover main roads coming into and out of Moscow?
Yes,
And did you attempt to make preservation of any items? What items did you want preserved?
I was trying to see if they had saved video or still images from those files.
What did you learn?
That I do not retain those.
Did you, when you say they do not retain those, do you mean they don't retain videos or pictures or both?
Both.
Did you do a preservation for anything?
Not recall sending actually a preservation letter out.
Okay. Your Honor, if I can have another exhibit provided.
Yes, thank you.
I'm keeping an eye on today's stream when it starts. I'll pause this one and switch to the current one. Just FYI. I'll let you guys know though, so you guys aren't like, what the heck just happened? And if anybody missed it, she's now asking him about how he viewed the videos, any type of surveillance where they see Brian Koberger's car or alleged car. Oh, a jury question in Daybell. Do we know the question yet, Ariel?
What do you recognize that exhibit?
So these are emails that I was trying to find some kind of contact information for windy.com, the website that does weather-related information, as well as some links to images from cameras that are covering the highway.
And did you learn that you could have some still shots preserved?
I did.
Did you have some still shots preserved?
I did not.
Okay. Your Honor would move for admission of defendant's PP.
She made sure to say that.
P, yes.
Yeah.
That's what I thought. Okay. Exhibit PP is exhibit.
He did
or
it.
Admitted. No, yeah.
Sometimes I'm like a teenage child.
When we started talking, we talked about you kind of being the guy that would book or take videos in from different agencies, even if you didn't verify what was on the device you received. Is that right?
Yes.
And I have a specific one a couple of them I want to ask you about. One is from Red Star Coffee Shop. Do you recall receiving that video?
I did not.
Okay. And are you aware that it was booked in or brought in by Idaho State Police?
No.
How would I find out about those videos?
I don't know. You'd have to go through the USB drives to find out what was given. I was just given the mass USB drives. I was not given them by the people that were bringing them in for time. Given to them after it had been handed off to other investigators and other assistants that were helping.
Is there somebody else I should ask about specific ones to track where they went?
I don't know. I don't have that information.
Okay. All right, give me just a minute, Your Honor.
Sure.
Thank you, Detective Mallory. I don't have the other questions for now, but hold on, the prosecutor might.
Okay, so today should be starting, so I'm going to bring that one over. And let's see. I just saw them kind of peeking into the courtroom, so it should be. Law and Crime should have it pretty quick here.
Now on the state versus Brian Koberger.
Might just go straight from his. Hold on. If they're not gonna. They're not gonna refresh and actually get in the courtroom. I'll just go straight from Judge's.
Is also subbing in for Ms. Beatty. Do I have that right?
Yes, Your Honor.
Okay, thank you. All right. We have motions to compel discovery, 4th and 5th. There have been some supplements in more recently. I think I got a couple on May 28th, I believe. So we need to sort that out. That's going to be in the morning. And that is open, obviously. And afternoon, starting at 1:30, we're going to address genetic genealogy. I think that's the plan. Okay, so starting with you, Ms. Taylor.
Thank you, Your Honor. After last week, we had one witness testify, and I have 2 additional witnesses this morning, and then there will be witnesses this afternoon in closed session as well.
Okay.
And I'd be prepared to call my next witness.
Okay, go ahead.
Call Brett Payne.
Okay.
So Brett Payne, if you guys,
Thanks, sir. Please come forward.
we've watched
Raise
a
your
lot
hand.
of his body cam
Do
footage.
you solemnly swear that the testimony you give in this case shall be the truth, the whole truth, and that's but the truth under penalty of perjury?
I do.
All right, thank you, sir. Please have a seat.
The cameras are way more crisp.
And then when you're seated, please state your name and spell your last.
Name is Brett Payne, last spelled Payne.
All right, thank you, sir. Ms. Taylor.
Thank you. Good morning.
Morning.
Will you tell us your occupation?
I am currently employed by the Moscow Police Department as the detective corporal.
What experience do you have prior to Moscow Police Department?
I was served in the military for 6 years. 3 of those were as a commissioned officer in the military police corps.
How long have you been with Moscow Police Department?
6 years.
We're here to talk about the case of the state of Idaho versus Brian Koberger. Have you worked on that case?
Yes, ma'am.
What is your role in that case?
I was assigned as the case agent for Moscow PD for that investigation.
Does case agent mean you're the person in charge?
Yes, ma'am.
If I called you the lead detective, would that be a term that means the same thing as person in charge and
Yes,
case
ma'am.
agent?
Yep.
Okay, thank you. What were your general responsibilities as the lead detective in the case?
So when I became case agent, I was assigned to work the command post that was established at the Moscow Police Department, along with my partners in Idaho State Police and the FBI. We managed the command post and directed the general direction of the whole investigation.
Would that mean you would be a person to write warrants and affidavits in support of warrants?
Yes, ma'am.
Did you conduct or direct interviews?
Yes, ma'am.
And did you search for a suspect?
Yes, ma'am.
Were you the go-to person and the person in charge for evidence that would be brought into Moscow Police Department to support your case?
No, ma'am, I was not.
Who's in charge?
That would have been our evidence custodian.
As the lead detective, were you aware of the evidence that would be under the control of the evidence custodian?
Not entirely. I was made aware of basically the most pertinent evidence that was coming in, but was not aware of every single piece of evidence that was brought into those.
Okay. During the course of, I guess, the investigation from November 13th forward, was there videos that were collected, like a video canvas done of the community?
Yes, ma'am, there was.
Is that something you were involved in?
No, ma'am, I was not involved in the direct collection of those videos.
Who is responsible for the video collection and knowing what videos exist?
So the way that worked was individual investigators who went out in the community and collected those videos, brought them back to the police department and provided them to our digital forensics office. And then they were later booked in through that channel.
So the digital forensics office would be the responsible entity to receive these pieces of video surveillance, is that right?
Yes, ma'am, I would say it was a dropping off point for those pieces, yes.
And who is that person?
That was a joint effort between Detective Marcie and several people within the FBI.
Which people within the FBI?
I do not remember.
Detective Payne, I'm asking because last week, Detective Marcie told us that he wasn't in charge of these videos. And I need to know where they are. Do you have any idea who the FBI agents are that were also in charge of this?
I think we could certainly find that out for you, yes, ma'am. I don't know off the top of my head.
Okay, well, I'm gonna need to do that. Let's talk a little bit about what surveillance is out there. These were cameras from different businesses, is that right?
Yes, ma'am, as well as some private residences.
Let's focus on the businesses for just a minute. Those would be collected at main points in Moscow where you might find a person of interest, is that right?
Yes, ma'am. We canvassed pretty much the entire city of Moscow looking for places that were willing to or could provide us video.
And was it also important to think about if somebody were to come into or leave Moscow, the kind of video cameras you might find on those areas?
Certainly, yes, ma'am.
And that would be the east-west road between Moscow and Pullman, is that right?
Yes, ma'am. Referring to SR 270/Pullman Road. They wanted that to refer to.
I know that as the Moscow Pullman Highway.
Yep.
I think that's the same thing, or Highway 8.
Works for me.
And that goes from Pullman out towards Troy in that area.
Yes, ma'am.
Okay. And also important in that video collection would be the north-south Highway 95, the north end of Moscow and the south part of Moscow. Is that
Yes, ma'am.
okay? And so you collected business videos or had that done, but who I need to talk to about this would be Detective Mallory or an unnamed FBI agent. Do I
Or
understand that?
the agents who were the officers, investigators who collected that specific video would have written reports, to the best of my knowledge, stating such that they collected video from X, Y, and Z. That would be the best person to speak to about that particular video.
But if they collected it and gave it to Moscow Police Department or the digital evidence people, isn't it your department that I'd be looking at and say, where is this now?
Yes, ma'am.
Well, I'm going to talk about some of those specific ones, but you brought up residential cameras in that canvas as well. Are you talking about things like Ring cameras?
Yes, ma'am. Ring cameras and other sorts of private security systems that people may have had.
Ring cameras have a way of sending out a notice to Ring camera owners to check their data. Is that right?
I believe so.
Was that done in this case?
I do not remember if that was done or not.
Are you familiar with some of the Ring cameras or home surveillance videos in this case?
Yes, ma'am.
In particular, I think your affidavit talked about one on Indian Hills Road. Do you know what I'm talking about?
Yes, ma'am, I do.
How did that camera come to your attention?
I believe Detective Vargas works for MPD. She contacted the residents at that, or the person who lives at that residence, and they provided that camera footage to Detective Vargas.
Do you know why she contacted them?
I believe it was part of just the video canvas, best of my knowledge.
Now, I want to talk about some of the specific businesses, and you mentioned that I'd be looking at a police report to tell me if it existed or not. As the case manager or the detective, are you familiar with the reports from other officers that may have talked about turning in videos?
Some of them, certainly not all of them.
Your Honor, I'm going to ask that he be handed two defendants' exhibits. They are RR and SS. No,
Thank you.
one of the videos I want to talk about comes from the Red Star Coffee Company. Do you know where that business is located?
Yes, ma'am.
Where is it?
That's on Pullman Road and right next to the Steamer Station.
So the Pullman Road that's also known as Moscow Pullman Road, that within the city of Moscow?
Correct.
Okay. And if you look at exhibit RR, and if I can draw your attention to on page 2 to paragraph 9 and page 3, paragraph 9 continues over there. Based on your review of that, am I correct in believing that the Red Star surveillance video was collected and given to Moscow Police Department?
It reads that way, yes, ma'am.
Where is it?
I do not know.
Who do I ask where it is?
That would be through the evidence custodian and MPD. That'd be my best direction for you.
So I need to go to the evidence custodian and ask him to bring all of the videos out so I can watch them all to see if that one exists.
Yes, ma'am.
How many hours of videotape do you think have been collected?
A lot.
Thousands?
Yes, easily.
Not how it works. The defense.
Detective Payne, I want to look
Find the evidence
at
itself.
defendant's exhibit SS now. Don't put our away. I think we might go back there in just a minute. But SS, if I can draw your attention to paragraph 1.
Okay.
Would I be correct in believing that I should be able to have a videotape from a place called Monday's Machine?
Yes, ma'am.
Where's Monday's Machine?
I don't know where Monday's Machine is, ma'am. Does not sound familiar to me.
Can you see the address that's also listed in paragraph 1?
Yes, ma'am.
Does that help you know where Monday's Machine might be?
It'd be south of Moscow city limits if memory serves, but that's the best I can recall.
You don't know where this particular numbered address on South Main might be?
No, ma'am.
Well, let's go back to, let me ask you this. Who do I ask where that video is?
Restate what I did before is go through the evidence custodian at Moscow PD.
Let's go back to RR for a minute, and if you can turn with me to page 4. I'll draw your attention to paragraph number 21, particularly subparts B, C, D, and G. Do you see where I'm talking about?
Yes, ma'am.
And there, we're talking about 4 different businesses all within the city of Moscow. Is that right?
That is correct.
And those are on Main Street in Moscow. Is that also right?
Yes, ma'am.
All right. And if I read the first sentence in that paragraph, am I correct in believing that Moscow Police Department should be in possession of all of those videos?
It reads that way. Yes, ma'am.
Where are they?
I would have to direct you to the video that have been turned into the evidence lab at Moscow PD.
I want to talk a little bit. I'm going to move from videos now, and I want to talk a little bit about affidavits and search warrants that you wrote.
Can I ask a question? You're not asking to admit these exhibits?
Your Honor, I haven't.
I just wanted to make sure.
Yeah, I haven't. The court has those in a pre-filing to put the court and counsel on notice of things we talk about. I'm not going to ask that these be admitted this way. Detective Payne didn't write them, but he's familiar with the content, so I think I have your questions answered. Thank you. Let's talk about affidavits and search warrants for a minute. Did you author affidavits in this case?
Yes, ma'am.
And did you use affidavits you authored in support of search warrants to obtain information that you wanted to take a look at?
Yes, ma'am.
And did you author the affidavit that was used for the arrest warrant for Brian Koberger?
Yes, ma'am.
What did you rely on when you wrote these affidavits?
Be more specific.
Yes, let's focus on the affidavit for the AT&T records. There were 2 search warrants on December 23rd, 2022. Are you with me?
Yes, ma'am.
Okay, so let's talk about those search warrants and the affidavit. First, the affidavit. What did you rely on in the affidavit you wrote for the first AT&T search warrant on December 23rd, 2022?
It was a conglomerate of interviews, data received from cell phones, my observations of some surveillance footage that was taking place, various other things. Go down the line. If you could be more specific on specific parts, I'd be happy to tell you what I'd like.
Okay. There was a part of the affidavit where you talked about WSU officers identifying white Elantras.
Yes, ma'am.
And there was a part of the affidavit where you talked about 2011 to 2013 Elantras, and then it expanded to 2016 to include the year of 2016 Elantras.
Yes, ma'am.
What I want to know first is what you relied on to expand that search from 2013 to include 14, 15, and 16.
That information was provided to FBI Special Agent Imel. He's a vehicle identification specialist. He used snapshots from the previously mentioned surveillance videos. And that was his determination on the types of vehicles we should be looking for, rather the year range we should look for. It would be in his report, we'd be more specific, but that was what I based the affidavit off of, that portion of it.
I understand as far as when we get to 2013, but when we go beyond that, what did you rely on to get beyond that?
It would have been his input as an expert in vehicle identification. That's what we relied on.
Part of your affidavit talks about WSU officers finding white Elantras. And I believe there was an officer that you had some communication with. Do you recall the date you had that communication?
I do not recall the date.
Did you have some messaging system exchange with this officer to talk about that?
Yes, ma'am.
Is that the only means of communication you had with this officer?
No, ma'am. I believe I spoke to him on the telephone as well.
When you spoke to him on the telephone, how did that relate to the date of the messaging?
It would have likely been, if memory serves, it would likely been that same day.
Okay. Does December 20th, 2022 sound familiar to you?
Yes, ma'am.
And so this conversation with this officer from Washington, it related backwards to when he noticed an Elantra, is that right?
Yes, ma'am.
But when he noticed it, you didn't know about that yet. Is that also correct?
That is correct.
Okay, so you don't know about him or talk to him until December 20th, 2022, correct?
Yes, that's correct.
In your affidavits, did you rely on cell phone information and cell phone location information?
Yes, ma'am.
Did you work with cell phone records yourself?
No, ma'am.
Did you see cell phone records yourself?
Yes, ma'am. I did.
When was the first time you saw cell phone records that were attributed to Brian Koberger?
I do not remember what date that was.
Well, maybe you can give me an estimate. We know on the 20th, you're talking to WSU about an observation from a month before. And we know on December 23rd, you're asking for AT&T warrants for information. Can you narrow
That's
it
a
down?
yes.
Sorry, Judge.
That's a yes. You can, I just want to get the record. Yes.
Yes, that's
Okay,
correct.
thank you.
So between those 2 days, does that help you identify the first time you saw cell phone records related to Brian Koberger?
Memory serves, the first time I saw any cell phone records related to Brian Koberger was after we received the return from the first search warrant.
Just to be sure I'm tracking with you, when you say the return from the first search warrant, we're talking about the first AT&T warrant.
Yes,
Is
ma'am.
that right?
That's correct.
And in that warrant, you were seeking 48 hours worth of records, is that right?
Yes, ma'am.
Okay. So if I call those the 48-hour records, we'll both be on the same page?
Yep.
All right. You wrote your second AT&T warrant for a much longer period of phone records that same day, December 23rd, correct?
Yes, ma'am. That's correct.
How far ahead of that warrant did you see the records?
It would have been upon the receipt of the 48-hour records that came in from AT&T. Immediately after receiving those, I began writing that second section of the second AT&T warrant for the longer period. That makes sense.
It does. So you get these records and you take a look at them and you start writing your warrant. Is that right?
The records were provided to FBI Special Agent Balance, who began deciphering them. I'm not an expert in cell phone records.
That was the next thing I was going to ask you.
So, no, ma'am, I'm not. So he was the one who was conveying that information to me so I could understand what it was.
So do you get the records and then get them to him somehow?
Yes, ma'am.
The records do they go directly to Balance?
I do not recall what the distribution was on the return itself. I do not recall that.
Are you and Balance exchanging emails about these records?
No, ma'am, not that I remember.
How did you get them to them?
We were co-located at the time. Detective Balance was at the Moscow Police Department about 30 feet down the hallway.
Are the two of you exchanging text messaging during this time?
I do not remember if you texted during that time.
I may have a record that would refresh your memory. I'm certainly not seeking to have these admitted, but I'd like to hand him some records to see if we can refresh his memory. Do you recognize what's been placed in front of you?
No, ma'am, I do not.
Okay. Does reading the content of some December 23rd messages refresh your recollection about participating in text messages with Nicholas Balance?
It really does not, ma'am.
Will you look at, there's 3 separate stapled documents. Will you move that one and go to the next one?
Still on December 23rd?
Yeah.
I do vaguely remember that exchange, the one at the top of this second.
Is that the one that starts with you identifying yourself?
No, ma'am, it starts with the message says, group text for this weekend, Maria, Nick, Ed, Brett, and Darren.
You look at that third one.
Seems vaguely familiar.
Okay. So just so I'm clear then, Nick Balance is at Moscow Police Department when you're getting, on December 23rd, when you're getting these 2 warrants. Is that right?
If memory serves, that's correct.
Okay. Well, you told me that you're not the guy who understands how to interpret these records. Do you know anything about cell phone towers?
Very little, ma'am.
Okay. So when you wrote this second AT&T warrant, you have possession of Brian Koberger's call detail records or AT&T records, but you don't know what they mean, so you're relying on somebody else.
Yes, ma'am.
Who all did you rely on?
Mainly it was Special Agent Balance. He was my main point of contact for understanding what was going on.
Okay. In fact, in your affidavit for the second AT&T report, there's a couple of maps in there. Is that right?
Yes, ma'am.
And one of them has some video camera information. That's the first map. Where did that come from?
I do not recall. If you have a copy of it, I can refresh my memory and tell you.
I bet I do. I have what we've marked defendants B.
Are you referring to there's 2 maps, the WSU focus map you're referring to? It's completely washed out on this copy. You can see what it is.
It's hard to see, isn't it? What I want to know is what you relied on to get that first one that talks about WSU and the cameras of WSU. Where'd you get that?
Yes, ma'am. So Special Agent Rob Hilley with the FBI was also co-located with us. He was tasked with analyzing that video from WSU and the surrounding area. So it was a conversation between he and I, pointing out areas of locations where the car was likely seen on surveillance footage. And that's what I relied upon to create that map.
So you created that map.
Through PowerPoint, I believe, ma'am, memory serves.
You saved your work on that?
Yes, ma'am.
Let's go to the next map. That one would appear to be a trail or a path from south of Moscow back towards Lewiston or back towards Payne. Is that right?
Yes, ma'am.
Where did you get that map?
Same thing, it was just created using open source satellite imagery and I think it was PowerPoint.
Did you create that?
Yes, ma'am.
Where did you get the information to draw that trail?
So that was used from the cell phone records referred to me by Special Agent Balance on his interpretation of possible places where someone could have driven between the location that it starts there and then back to Pullman.
So you did this on some open source mapping, not anything from Nick Balance creating a visual for you.
No, ma'am. I did view a draft report from Special Agent Balance to help me conceptualize this, but it did not look like this map.
Where's that draft report?
It is, best of my knowledge, it's already been provided to the prosecutor's office through the FBI channels.
Is this the lengthy past draft report or is it a different draft report?
Well, it would have to be the draft cast report. That's the only cast report I'm aware of from Special Agent Balance.
So on December 23rd, are you saying you looked at this past draft report to make that map that went into your affidavit to get the second set of records?
Yes, ma'am.
The one that was given to us in July of last year?
I don't know when you got it.
How many versions of that cast draft report have you seen?
I've only seen that one, ma'am. That's the only one I'm aware of.
All right. And from the FBI, we have Agent Balance and Agent Hilly at Moscow Police Department with you. Yes,
Yes, ma'am.
and all of this work is done with verbal communication, is that right?
The majority of it, yes, ma'am.
And Nick Balance's cast draft report.
Correct.
And I think Special Agent Imel's vehicle identification.
Yes, ma'am.
Okay. Let's talk about what you were seeking to get in this. Well, let me ask this before I leave the second search warrant. Is there anything else you relied on to obtain that second search warrant to compose your affidavit?
Like I said earlier, we relied on cell phone records from surviving roommates as well as the victims. We relied on interviews with the two surviving roommates that were present at the time. We relied on the surveillance footage, cell phone data. I'd have to go paragraph by paragraph, but that's what jumps to mind.
Of those things, are you relying on other people's work to put that all together?
Yes, ma'am.
Okay. Now I'm ready to talk about the things that same day as the first one. And was there anything else from AT&T that you saw or relied on to get the second one off the ground?
No, ma'am.
And in the first AT&T search warrant, are you aware that part of the request was for timing advance reports?
Yes, ma'am.
And in fact, that also appears in your second search warrant request, right?
Yes, ma'am.
All right. And not only do you ask for the timing advance reports from AT&T, you ask for them from several other companies, correct? Verizon's version of it, T-Mobile's version of this kind of timing advance report. Is that right?
Yes, ma'am.
All right. When was the first time you saw AT&T's timing advance?
I do not recall when I first saw it.
Where is it?
To the best of my knowledge, all of that information from those returns has been provided to the prosecutor's office.
If I tell you I don't have a timing advance report or any from the other phone companies, where do I look for them?
I would direct you back to the prosecutor's office. Everything that Moscow PD received, we, in that realm, we have turned over to my knowledge.
But you know you've seen this report, is that right?
I do not recall if I've seen the timing advance reports. I'd have to see what it even looked like to know if I'd seen it.
Do you know what it is?
Not particularly. I'm no expert.
Okay, you wrote the search warrant though, right?
Yes, ma'am.
Well, how did you get the language for that if you don't know what this is?
So there's no secret that I rely heavily on people who are very highly educated in these topic areas to write this search warrant. So that language was likely conveyed to me through people who know much more than myself about cell phone data.
Who are those people?
Like I said, FBI agent Balance and Detective Mowry were probably my two main points of contact for helping me with that language.
During the course of your investigation and work on the case that became the case that we're here for now, did you communicate with Agent Balance by email?
Yes, ma'am.
And did you communicate with other FBI agents by email?
Yes, ma'am.
And did that relate to the investigation of the scene and later the investigation of Brian Koberger?
Certainly, yes, ma'am.
Were those communications that assisted you in preparing affidavits and search warrants to carry out your duties in the case?
I do not recall.
But you recall the emails themselves.
I recall sending emails to FBI agents, yes, but
And-
specifics, no.
And receiving them?
Yes, ma'am.
Where are those emails now?
All emails that Moscow PD is aware of have been turned over to the prosecutor's office.
Your Honor, if I could have just a minute.
Sure, thank you.
Thank you. I don't have any other questions for now, but I think you have a couple of exhibits on that front end. If you don't need them for us, maybe I'll take them back.
Well, hold on. Do you have any questions?
Yes, I'll.
Yes, okay. I thought you were just stepping off, so. Jennings?
Yes, thank you.
Go ahead.
Morning, sir.
Good work.
To your knowledge, have all the evidence in Moscow Police Department's possession been turned over to the state for us to discover?
Yes, ma'am.
Have you facilitated the defense visiting MPD to review the physical evidence in this case?
Yes, ma'am.
Approximately how many times have you done that?
I had to guess, I'd say 6.
Now, let's talk specifically about this video surveillance. Explain to me the process for collecting video surveillance.
So in this investigation, the way that played out was we directed the investigators to go into the community and collect any available surveillance footage there was. Once they had done that, they were tasked with bringing it back to Moscow Police Department, placing it in the digital forensics lab, and then writing a supplemental report on where they collected that information. That was the process.
Do you know how many agencies helped in this video canvas?
Certainly the FBI and the Idaho State Police. I'm not sure if any other agencies helped. I don't know.
Do you know approximately how many agents were out collecting video?
Easily over a dozen. I don't know the specific number, but
Isn't it true that investigators collected video surveillance from approximately 79 businesses
yes, ma'am.
and approximately 10 residences? So let's talk about the areas that Ms. Taylor mentioned. Isn't it true that there's other surveillance video capturing the Moscow Pullman Highway, specifically on the way to Pullman?
Yes, ma'am.
Isn't it true we've turned over video for banks
Yes,
on
ma'am.
that highway? Isn't it true we've turned over surveillance for stores on that highway?
Yes,
Isn't it true we've turned over video for gas stations?
yes,
Now let's talk about the Troy Highway towards Troy. Isn't it true we've turned over surveillance video for fast food restaurants,
yes,
gas stations?
yes,
And now US 95 towards Coeur d'Alene. Is it true we've turned over surveillance video for hardware stores,
Yes,
gas stations?
yes,
Now, what about US 95 towards Lewiston? Is it true we've turned over surveillance video for gas stations,
yes,
as well as apartments?
yes.
Now let's move to your PC affidavit. Can you explain to me what did the investigation look like during the time that you were writing that affidavit?
So as I said, the command center was established at the Moscow Police Department. The command center consisted of myself and numerous partners from the FBI and the Idaho State Police. We were all co-located there at Moscow PD. We also had individual sections assigned to do various tasks, collect video, conduct interviews, so on and so forth. The majority of those people were also co-located at the Moscow Police Department. So as the process for developing this affidavit began, those people would just come into the command center and relay information that was deemed to be critical or important. The reason for that was to shorten the chain of information to make sure that the folks, myself and my partners in the command post, got the clearest view of what the investigators on the ground were actually retrieving and learning as this went on. As they relay that to me, I can put that into the affidavit.
And is that standard to rely on what other investigators tell you when you're applying for warrants?
Absolutely.
And is that what you did?
Yes, ma'am.
And is what you relied upon detailed in your probable cause affidavit?
Yes.
Now, talking about the timing advance records, are you aware that AT&T didn't provide timing advance records in December of 2022?
I do not remember.
Are you aware that they did not start providing those records until May of 2023?
Objection leading.
Cross-examination.
It is overruled. Go ahead.
I'll re-ask. Are you aware that AT&T did not start providing those records until May of 2023?
Yes.
I don't have anything further.
Thank you. Ms. Taylor?
Thanks. Let's start there. May of 2023. Do you have timing advance records now from May of 2023?
I would have to direct you to Detective Mallory to answer that question. Don't know.
Okay. Did you write a new warrant for them in May of 2023?
I do not recall.
If you included them in two separate warrants in December of 2022, but they didn't provide them, why would you do that?
It was the language that was suggested to me to write the affidavit, so.
Language suggested by an FBI agent who's an expert in the field?
Yes, ma'am.
Yes. And do you know if he saw the timing advance reports?
I do not know.
All right. Now, those first and second AT&T warrants were how many hours from receiving the return on the first one until the second one was given to Judge Marshall at 4:45?
I do not remember.
Not very many hours, though. Would that be fair?
Likely not.
I want to talk a little bit more about the video and what's been turned over and what hasn't been turned over to us. And I want to focus a little bit on South US 95. Do you recall that south of Moscow on US 95 is the path that you put in your search warrant and affidavit alleging that Brian Koberger left Moscow going south on US 95?
Yes, ma'am.
All right. And are you aware that one of the videos that you gave us, the coffee shop there on South 95, that leaving Moscow, you have to pass that covers 5 a.m. to 6 a.m.?
I do not recall the time frame for that.
And so the time frame in these videos would matter, right?
Certainly.
The time frame in the videos to be meaningful would need to cover a time that surrounds the allegations against Mr. Koberger. Is that fair to say?
You could say that, yes.
Okay. And are you aware that Watson Kari Construction had a video, and that also has a very limited time frame, like 5 a.m., just 1 hour of video also.
Sounds vaguely familiar, yes.
And that's also south on Highway 95. Is that right?
Yes, ma'am.
And the one we talked about today, Monday's machine that nobody could find, that clearly was given to Moscow Police Department, that's also south on 95.
Yes, ma'am.
Okay. I understand that you had a lot of help on canvassing and collecting things. There was a lot to do. But as the lead agent and the lead department, is there some kind of inventory of these videos, like a general inventory that would help me know what you have and why you don't have the relevant timeframes?
The inventory that would be most useful to you is the inventory of evidence that has been booked into the Moscow Police Department. That's the inventory.
And I did come see the evidence. That's fair. I did come see the evidence. We didn't watch videos together though, did we?
No, ma'am.
And would you agree that that evidence is on thumb drives with stickies on papers that tell us different things, but not like an inventory of what's on each thumb drive?
I am not aware of an inventory of each individual thumb drive.
Okay. So for us to do that together would take some days to inventory it all together. Is that right?
Yes, ma'am.
And that's my best way to try to find this Monday's machine
Sure.
and Wasankari Construction.
Yes, ma'am.
That's it. Thanks.
All right, Ms. Taylor, anything to follow up on that, Ms. Jennings?
Oh, just one second. Thank you. I just want to clarify what's in your probable cause affidavit. Does your probable cause affidavit state that Hope River or White Elantra went on US 95 south of Moscow?
No, it's not.
Okay, what does it state?
Memory serves states that the next time, well, it states that a vehicle was seen leaving the area of the crime scene, on King Road, leaving via Walenta Drive, which heads south from that area, and then terminates on Conestoga and Moose River Drive. That's what the probable cause affidavit states.
And to your knowledge, are there other paths of travel south of Moscow besides US 95?
Yes.
And what's that other route?
I believe the one that was referenced in the affidavit goes from Moose River Drive, which turns into Sand Road at the state line, not the Idaho-Washington state line. That road continues westbound until south of Pullman and eventually leads north into Pullman at Bishop Boulevard, if memory serves.
And does that path of travel go by Wasankari Construction?
I do not believe it does.
Did you attempt to obtain surveillance on that path of travel that doesn't go through 95?
Yes, we did.
And were you successful?
I don't believe we were.
I don't have anything further.
Okay, thank you, Ms. Taylor.
Are you testifying that Mr. Koberger did not use Highway 95 south of Moscow on November 13th?
I'm testifying that there are various routes that a person could take south of Moscow to include Highway 95. There are also several others.
Which one does your map depict?
I believe the map starts well south of Moscow, forward more towards Genesee, and there is the line that starts there. However, I would direct you to the paragraph at the beginning of the map that says this is a possible route to travel between the two locations.
So you're just not sure.
Yes, ma'am.
Okay. That would include then Highway 95 south of Moscow.
Yes, ma'am.
And that would include other possible routes.
Yes, ma'am.
How many video surveillance attempts did you make to get video from businesses or homes on all of those routes?
I do not recall, but it continued for some time, attempting to find additional video footage.
What did you find?
Nothing to my recollection.
Not one video depicting the car.
To my memory, no.
Good enough, thanks.
All right, thank you. Okay, great. Can this Detective, Payne be excused at this point.
He can be, thank you.
Okay, any objections? All right. Thank you, sir. Thanks for being here.
Okay, so essentially, she's saying, "Hey, we don't have these certain videos that you seem to be referencing in your probable cause for arrest and your search warrants that you're requesting." And he's saying, "Well, hey, I don't know. The only way to know which videos we have is to go to the custodian yourself," which is interesting because that's not how it works. Like the DA actually has to give over all the videos, and that's the bottom line. Well, the prosecutor is actually arguing here, saying, well, we gave them all of these things, which are the only ones that are important, and that the other ones, it's going to go back to like the same shit we talk about with all these other cases. The other ones aren't important because they're not actually exculpatory. They're not anything. So we don't need to worry about the other ones. So we gave you this, 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 and this. So just be happy that you got that. And she's like, well, she comes back, which is perfect, and says, hey, well, are you sure of which one it even is? So it could still include this one that you put in here. And he's like, well, yeah. So then she's like, well, then it isn't something that you wouldn't turn over. So what you're saying is essentially, I have to go sit there for days on end and watch the videos on each thumb drive because you guys couldn't figure out how to label the thumb drives with which surveillance is on which. And you guys know, like I said, I'm on the that I think Bryan Kohberger is the right guy, but that doesn't mean that this stuff is not questionable. I do think that I think he was very honest. I don't think he's qualified to be doing what he was doing. He didn't have the experience or the know-how to be able to do any of this stuff. And not to say that they can't talk to other people. Obviously, they're not the only one investigating. Oh yeah, I know, Ariel, you're right. But I'll get to it. But you're not the only one investigating. Plus, it's on long crime if I do it, you get cut off. So I'm not too worried. You're not the only one investigating, so people are helping you, but
Stay or leave.
Thanks, sir.
Thank you.
Your Honor, we call Siren.
Okay, thank you.
now here's the expert that they're going to use, the cell phone expert to use to say that Bryan Kohberger was at the park doing his
Thank
Stargaze.
you. Thank you.
Do you solemnly swear that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth, and penalty of perjury?
Right. Thank you. So you go ahead and have a seat there, and then please state your name and spell your last.
And he is controversial. He has some very good things in his past, but I've also gotten some articles sent to me
R-A-Y.
with some conflicts.
Say it.
So.
Thank you. Good morning.
Good morning.
Will you tell us what you do?
I have a handful of different jobs, but primarily for my role here, I do a lot of consulting, analysis, and evaluating geolocation data as it pertains to mobile devices.
Let's talk about how you got to that place where you, by consultation on devices and geolocation.
Okay.
What background led you to this job?
I started with a law enforcement background. I started my law enforcement career in 1995 in Arizona. Started working with the first set of cell phone records in that capacity in late 1997. There wasn't a lot of training. Obviously, cell phone technology and the use of that in criminal investigations was very new and novel at that time. So most of my early training came directly from the carriers. If I was working a case with Verizon or AT&T, I would work directly with Verizon or AT&T engineers to understand the records, what they meant, how to map them, how to interpret them. In 2000, I started a very small police department in Arizona. In 2000, I transferred to a much larger police department in the Phoenix area. When I made that transition, I took more of an investigative role. I was previously a patrol officer. That investigative role, I started with a DEA task force where I worked with drug narcotic interdictions, and the primary role there was working with cell phone records. So I had some more training experience in that capacity. In 2001, late 2001, I left that position and I went into a full-time investigations position. I started with sex crimes and child crimes, again, using cell phone records and attending what training was available. Again, most of that is from the carriers directly. About 2004, I moved out of sex crimes and child crimes into persons crimes or violent crimes. So any type of a dangerous or violent crime against a person. Continuing to work with cell phone records and attending what training I could. In 2008, I was promoted to sergeant, and I was immediately put into a homicide robbery sergeant's position, where I stayed until 2010. Around 2004, I started doing a lot of work with cell site simulators, and that is a piece of equipment that allows you to physically go out in the field and find a mobile device. In a very brief summary, it's the ability to create a fake cell tower that is mobile, it's in a vehicle, And if I can analyze your phone records and determine a rough area that you're at, I can put this mobile platform in that area. Your phone will register to it, and I can physically track the phones. It's in court, it's in a bedroom, wherever it may be. In 2007, our agency purchased that equipment. So prior to that, I was working with other agencies looking for devices using it. 2007, we purchased our own equipment. That purchase also prompted more training. There was a company owned by Boeing. They came in and I had 80 hours at that point specific to cellular network engineering, how to go out and actually conduct these surveys to understand how a particular cell phone network works in a particular area, how to replicate, how to create a cell site that looks legitimate in that area. I worked with that company for a number of years in doing that, hundreds of hours worth of back and forth working, actually going out in the field and doing this. In 2010, I had an opportunity to go to Afghanistan as an advisor in charge of an undercover Afghan police team that targeted IED cells. And again, we would look at different types of technology that we could leverage in doing that. I came back in late 2010, early 2011, and went back to the police department. In 2012, our department created a position that this was a full-time position. That's all I did was track phones pretty much every day, using cell site simulators, using phone records, whatever technology we could leverage. Because of the lack of training that was available when I was a younger officer, in 2007, I started a training company, at the time it's called Phoenix Training, and I created a training company to provide law enforcement training, specifically as it relates to cell phone records. I've been providing that training from 2007 up to about 2013 now. I was really frustrated with the lack of software and training available to law enforcement. Very complex and clunky, for lack of a better term. So I began researching and teaching myself how to do some basic computer programming, and I wrote a program that I could take phone records from any carrier in the United States, and I could put it in this program, and it would immediately map hundreds, if not thousands, of connections. It was pretty unique at the time. There just wasn't a lot of options out there that was doing the geolocation. There was a lot of analytics to who's calling who and how often they call that person. But specifically to put it on a map for detailed geolocation data, there was a big gap in the market. It worked really, really well. And at the time, because we were tracking phones in the field, it gave me this very unique opportunity where I could use a search warrant, get phone records, analyze the phone records, come up with a hypothesis that this phone is most likely Thursday at 2 a.m. going to be in this neighborhood, and then physically go to that location to recover the phone. And then I could evaluate, was I right? Was I wrong? Do I need to tweak something? Mid-2013, our agency was assisting a lot of other agencies because we had, for lack of a better term, we had progressed significantly on our ability to find phones. I had a lot of agencies asking me for a copy of my mapping program, and I was just about 20 years at that point. I realized maybe it's time to go do something else. So in May of 2014, I retired from the police department and I started a company called ZETX, Z-E-T-X. And we offered a couple different things. So we have the mapping program that I just described. Obviously, when I'm running it on my laptop, it can be a little clunky. It doesn't have to be perfect. When we started business, we actually hired computer engineers to come in and take what I had written and scale it to a national platform. So we offered the mapping services, which was both real-time and historical. We took that original training class that I had built and we scaled it out. So we had a basic 40-hour that would just give you the nuts and bolts of how to look at phone records, what they mean, what type of records to obtain. We also started a subject matter expert course. It was one of the first courses in the country where law enforcement could actually come in and become certified as subject matter experts in this field. Did some training courses as well that we created on drive testing, so the ability to go out and scan and monitor cellular networks. Because of those two features, my job duties changed dramatically, where I found myself consulting with law enforcement daily, sometimes multiple times in a day, on cases very similar to this case, where I would have a law enforcement agency that's using our product or has attended our training that would call me for some type of review or analysis. And I've lost count. It's thousands and thousands of cases. To put that in perspective for some just general numbers, I sold this company in 2021. At that time, around 2021, 2022, the system had mapped over 2 billion phone calls in the United States. We were seeing thousands of uploads a week. We had created this program in 2014 that if any law enforcement agency in the country called us because they had some type of crime, we would overnight them a drive test scanner, which gives them the ability to go out and do a forensic examination of cell tower networks. It was no cost. We ate all of the cost. So we paid for the scanners. Initially we paid for the shipping. And the idea there is we wanted to create a national tower database that would have just a collection of drive tests. I want to say we have over 3 million towers in that database today that have been scanned or measured in some capacity. I am unaware of any other database in the world like it. And we use that to feed the mapping platform to increase the accuracy of the mapping. Something that we did that was very unique with our company is we actually provided an estimated coverage area. So instead of just saying this phone connected to this cell site and the antenna points north, we would give the person doing the analysis a general idea of where that phone could possibly be within a radius. We were the only ones doing it when we did this. Since then, since 2014, more recently, since about 2020, pretty much the rest of the industry has adopted, if not the same standard, a very similar standard. So the company we were using to do the drive test data is a company by the name of Rohde, ROHDE, and Schwarz, SCHWARZ. They're a German company out of Munich. They've adopted the way that we were doing some of the ranging. The FBI CAS team has adopted that, has actually brought that tower density is what is the general term for it, and it's now a feature in the CAS bids program. So through the years with training, I've probably been involved in training 30, maybe 35,000 law enforcement officers from around the country. We had about 650 law enforcement agencies within the United States. At some point, all of the federal agencies have used our products in their training, and I've done quite a bit of consulting internationally as well. Towards the end of that period, we started working more with Rohde and Schwarz. Rohde and Schwarz decided that they wanted to look at the ability to implement a cell site simulator in the United States. They had one for Europe. They were considering doing it for the United States. So they sent me their first one for the United States, and I worked with their engineers for about a year, testing it, reviewing it, improving it. So another several hundred hours there. I've tried to figure out how many of these missions, if you will, of going out and finding a phone or looking at phone records, and it is literally thousands and thousands of hours at this point. I can't tell you specific number. But that would be the background.
Sounds like your background is mostly in law enforcement, and then you moved into a specialty with cell phones, cell towers, drive testing, radio waves, all of that kind of thing.
That would be correct.
Through that and through the training of other officers to do this work and to use your program, have you testified as an expert in this field?
I have. If it's not 100 times, it's right there near it. Roughly 100 times in both state and federal.
And have you been qualified as an expert in state courts,
Yes.
in federal courts?
Yes.
How about Idaho?
Don't think I have in Idaho. I've consulted on a lot of cases in Idaho, but I don't think I've ever had testimony in Idaho.
This your first time then?
I believe it is.
Generally, when you work, and I'm talking about when you've done your consulting work or worked with an agency to do what you do to review the records and to analyze the data, do you usually work with the defense?
This is the first time I've ever testified for this.
Fair to say you usually are a prosecution witness?
That is a very fair statement.
Well, here you are, and you're working with us in Mr. Koberger's case. What's your role in this case?
Trying to conduct an analysis of all of the geolocation data. At this point, still focused primarily on Mr. Koberger's device, ultimately all devices, but any geolocation data, which is the ability to look at a specific area, whatever range or size that might be at a specific time, and put some type of accuracy and reliability to a phone's travel. Maybe it's stagnant, when it's moving, when it's not moving, when it's off, it's on, those type of things, but specifically as it relates to network, so the cellular network or a Wi-Fi network, I am not a forensics digital guy. I don't get into cell extractions. I'm not looking at the metadata on the phone. I'm looking at it very much as a network.
If I can make a rough distinction, you're not the person that's going to tell me who they called and which Facebook groups they might be a part of. You're not going to look at the data from the phone like photographs, but you're going to tell me the places this phone went and how it was used while it went somewhere.
Kind of. Let me clean that up a little bit. I will look
first at where I believe the phone went, where it traveled, how it got there, how long it took, possible routes. And then to your point, I call it cooperative data. I'm then going to seek out all that data you just talked about to say, okay, well, we have these 3 photographs, we have this piece of surveillance video, we have these 4 receipts. I'm going to overlay it with my analysis so that I can corroborate the analysis accurate, or maybe we see activity associated with that person and the phone's not there. Does that person just not have the phone, or is part of our analysis wrong? Maybe surveillance details wrong. We don't know. So eventually I will get back to that data you're talking about, but I'm not the guy that's going to go out and extract that data.
Would it be fair to say that that's data that you would use in a final analysis as it comes in from other sources, but you're the go-to for me to understand how a phone works with a tower and how it moves between towers if the phone's in motion somewhere?
Yes, 100%.
You talked a little bit about drive test data or drive testing, and that being part of the company that you developed and part of the work that you've done. Is that helpful in understanding the ultimate picture?
Depending on the type of records we're dealing with, it can be very helpful. When we're looking at just basic call detail records, CDRs, a lot of times we're just getting connections to a particular cell site, and we can say a PSI of that cell site. Sometimes the frequencies that are used. Drive testing is really the only way to get a little bit more specific with where that phone may be. But more importantly, we can start to rule out areas we know it's not by drive testing. So just think of drive testing as a forensic evaluation of the actual cellular network in a particular area.
Fair enough. Are you familiar with AT&T records?
I am intimately familiar with AT&T records.
How long do you think you've been working with AT&T records?
28 years.
In our case that we're here on today, have you reviewed any AT&T records that relate to Mr. Koberger?
I have.
What have you reviewed?
What AT&T refers to as their regular CDRs, which is a report AU as an atom union. I have identified the report CT as in Charles Tom, which is the subscriber information. There's a really weird name called Locabor, which is AT&T's attempt to estimate general locations using latitude and longitude. I don't want to say GPS because it is different than GPS. I believe I've looked at some Payne data from December. For the most part, that's what I've reviewed so far.
Have you looked at 2 separate AT&T warrant returns from December 23rd, 2022?
I have.
In your experience with working with AT&T records, is it common or uncommon to have 2 warrants, one that relies on the content of the first in the same day?
It's not uncommon to see a small time period that produces results that would increase the desire, the need for a bigger time period of records. Seeing that entire process happen twice in the same day is extremely rare.
The first AT&T record, we called it today the 48-hour AT&T record of Brian's call detail record. If you were to take that and do an analysis on a call detail record, how long would that be?
Depends on the analysis. So I'll qualify that answer with looking at what was put into the second warrant that shows us at least parts of that analysis to include a route that was identified. To do it reliably and feel comfortable that I'm accurate, at least 3 hours. And that's if you know what you're doing and you have all the tools at your disposal. Arguably, you could spend half a day or more doing that very easily.
To do that, do you just take these records, printed copy, and know what's on there, or do you have to do something with those records?
You would have to use some type of a mapping platform software, and you would take the digital copy, which is typically a text file, you would import it into that program, which would then map everything. But if I'm going to use those results search warrant affidavit, for example, there's a process that I'm going to go through to confirm the accuracy. Because in theory, if I'm wrong, the entire linchpin of that case is now hinged on this affidavit that I wrote. So before I commit to swearing out to an affidavit, hey, this is what the phone is doing, X, Y, and Z, there's a further process of just mapping it to validate it. In this case, there's a lot of time distance measurements that need to be performed that can be extremely time consuming. There's some ulterior issues that come up with how that phone is interacting with other cell sites that needs to be analyzed. Again, saying that a very qualified, competent investigator spending half a day just coming up with that basic summary is very reasonable.
In that half a day, you would put that record into a computer program and a map would be produced?
Correct.
What other information besides that call detail record would you need to do this analysis?
In this case, I would want the call detail records. I would want the locabor, it's LOCABR. And I would want the regional cell tower list from AT&T.
Does AT&T generally provide that regional cell tower list inside of its record that it produces pursuant to the search warrant?
No, I would actually say by policy, they do not. It's a very large file. It typically does not transmit very well to government email. So they would direct users of where they could go online and download.
And have you looked at this record, the 48-hour AT&T search warrant record, the return on that?
I have.
Did that include the regional tower list?
It did not.
Okay. So if you are doing this analysis, you put CDR records into a computer program, you put a regional tower list into the computer program, what does it produce?
The CDRs would show me cell sites that the phone connected to. In this case, even within 48 hours, there's hundreds of those cell sites. So it would take a while to really look at that. The regional cell site list would show me the cell towers that the phone's not interacting with, which can be just as important.
Does it spit out product to you, or does it create something that you can reference to write your next warrant?
Depending on which mapping platform you're using, they all create some type of a map that the person doing the analysis on can interact with, and they can change things, they can save things, they can create work product. Depending on that platform, that's saved in different types of maps, but yes, all of them would have some type of a mapping platform.
Okay. Would that be consistent with this past draft that we heard about earlier?
It's my opinion that Corporal Payne probably is misusing some terms there. I don't see any possibility of the FBI CAS team producing a CAS draft report on the 23rd. I think he's probably mistaken that he saw some type of CAS work product, which would be this map, before they export all those results into a report. So I believe that he probably saw some mapping through a mapping platform. It would really surprise me if there was a physical report. It would be completely out of character.
In that first AT&T report, did you, or request search warrant and affidavit, did you see the request for advanced timing reports?
I did. It's in both search warrants.
Did you get a copy of that in either return?
I have not seen any timing data in this case.
In December of 2022, did AT&T have this advanced timing report?
They absolutely did.
Was it something that they could produce?
It absolutely was.
And in May of 2023, but how's it different to that May of 2023?
Prior to May of 2023, only certain agencies were receiving this timing report, the FBI being one of them. What was referenced earlier about the May 23 date, that is when AT&T started offering the same type of reports. It's a little different, but it's the basic timing report to the state and local law enforcement as well. But prior to that date, state and local law enforcement would have to leverage these reports through federal agencies that had access to them.
let's talk about the return on the second AT&T warrant. Did that have the tower list, the regional tower list in it?
It did not.
Did it have call detail records?
It did.
What time span?
I believe it's from June 23rd of 2022. The historical was as of the date of December 23rd, but there was also a real-time pin register that was added that extended, I want to say, to the end of December, maybe very first of January.
What's a real-time pin register?
So the second search warrant asked for a couple of different things. Historical records going back to June 23rd to the current date, which was December 23rd. The second piece that was asked for is real-time data from the network, which is commonly referred to as a pin register or trap and trace. And it's the ability of law enforcement to monitor network connections in real time. So as that phone connects to the network for certain reasons, I can see those connections. It's not a wiretap. I can't hear anything. I can't see content, but I can tell the phone is connected to a particular cell tower. There's also what's referred to as Payne data, and that's going to be AT&T's estimation of where the phone is at, and that's provided by latitude and longitude, and that comes in every 15 minutes.
What is the purpose of one of those devices?
I should probably clarify. The third thing was the authorization for a cell site simulator. So it was a combination of all of these. Just as a matter of policy, and I think pretty much every law enforcement agency in the world has adopted this if they can. To use the cell site simulator, you want to see a real-time feed of the phone. Otherwise, you're driving in circles where the phone may not be. So it gives law enforcement the ability to have a general understanding of where a phone is operating or functioning. And then I can use the cell site simulator to do it. There's a number of reasons an agency might do this. This search warrant actually says they were requesting these because they were trying to locate where Mr. Koberger was.
Going to the understanding what's happening right now, is that used so that you don't just know where the phone was 5 minutes ago, but you know where it is right now?
Within a time period, it's not a perfect system. There is a little bit of a delay and the information comes in intermittently. So it's not a real-time feed of giving constant evaluation of where that phone is. But if you know what you're looking at and you've done it long enough, you get a pretty good idea.
I heard you say that this is to try to find out where Mr. Koberger is. In the information that supported this warrant, didn't they already know where Mr. Koberger was?
I reviewed a lot of documents that clearly state not only did they know where he was, they had a surveillance team with eyes on. So yes, it would be unusual for an agency to request this type of equipment. And I need to qualify that. This truck driving around is about $1 million. It's not something you just park in the garage at night. It's a very expensive resource. It's a very technical resource that requires a lot of training and skill to use properly. So typically when it's used, it is used for, hey, we don't know where this person is at and we need to find them. And to be very honest, I don't have an issue with that part. I've used it 1,000 times. It's a good tool. It's a great tool. However, if I know where a subject is and I'm physically watching him, it's probably disingenuous for me to get a search warrant justifying it that I need to find him.
Makes sense. Thank you. I want to switch gears and talk about the CASBIZ program.
Okay.
Are you familiar with the CASBIZ program?
I am.
Why?
I've worked with a lot of agencies that have used it and accessed it. So I've worked on cases where we've used different mapping platforms to do kind of a compare and contrast as a peer review. So they would create a work product, we would create a work product, and we would check each other's work. Because at the end of the day, we're just looking for the accuracy. We want to see if there's any errors in that. I would say I probably have worked with the CASBIZ reports several dozen times, maybe 50. I'm aware of some of the updates they've made. Like I mentioned earlier, I'm aware that they have added a feature that you can now input tower density, so you can create these estimated ranges, if you will. And I'm very familiar with the basic settings that you have certain controls you can do, like time zone. What time zone am I going to have it? Am I going to use the coverage density? Am I going to save my work? Am I going to just exit the program? I physically have seen those features a number of times.
As it relates to this particular case, have you had a chance to look at any exhibits prepared by Detective Mallory using the CAPTAVIZ program?
Yes, but I should clarify. One of them I'm pretty familiar with. I believe it's State Exhibit 48 that was used for the grand jury. The others I had never seen until I believe it was last week. So I'm probably gonna have to look at those if you're gonna ask me questions on those. But State's 48, I'm pretty.
I want to ask you a question about that. I'll ask you some other questions about the records we received last week. I'm going to have you handed what was admitted last week as States R, just my copy of it so that we know what we're talking about here.
Okay.
I'm curious about what was needed to go into CAPTAVIZ to create that.
So when I open the CAPTAVIZ program, I have to input what I'm going to refer to as source data. So let me define source data is any data that is an electronic format, typically a text file, that the CAPTAVIZ program is going to link to this mapping session and use that source data to create the images we're seeing. I can tell you right off the bat, without a doubt, this one is linked to two different source data. One is going to be a set of CDR records, so the regular AT&T CDRs. And then this particular exhibit would require the regional AT&T tower list, which is a text file that contains all of the cell site locations, most likely be Western Washington, Idaho, and Eastern Washington, Idaho, and Western Montana is typically that region. But there's no way this map was created without the AT&T tower list. It's physically impossible.
Is the AT&T tower list, was that contained in the call detail records that were obtained by search warrant relating to Mr. Koberger?
It was not.
All right. And in the CAPTAVIZ program, when you input the CDR call detail records and you input the tower list, does that program create any type of log?
It does, and I want to make the record really clear on what I'm testifying to, because it can get kind of confusing when we start talking about different versions. The CAPTAVIZ program offers two styles of mapping. I can just default to a normal size, what they're going to refer to as a wedge shape, which is representing the sector the device connected to. If I was doing that, all I need is the AT&T records, because the AT&T CDRs actually have the tower information that's required for that mapping. As soon as I change that feature, though, to add coverage areas, the estimated coverage areas, and now these little wedge shapes or these sectors are all different sizes, the CAS program has to be linked to a tower list that has location of all of those towers. That's the only way the program knows how to size the cell sites. So I just want to clarify, if I'm mapping the CDRs without coverage areas, all I need is the CDRs. If I'm mapping the coverage areas in the CAPTAVIZ program, I have to have a tower list. This one, I can see 3 different sectors. 2 of them, if anybody sees this exhibit, just to make the record really clear, they're really hard to see. One of them is just under the N as in Nora, under the word Pullman. The other one is right by the L in Pullman. But they're different sizes. And that tells me right off the bat that the AT&T tower list is used.
And why are they different sizes? Mind again, please.
Cell tower density, we see a great big sector right in the middle of this map, and I'm not familiar with the area here. It's basically south of Pullman and south of Moscow, kind of out in the middle of nowhere. Not a lot of cell towers out there, so one tower covers a very large area. Then the other 2 are going to be in Pullman. It's kind of hard to see on this map, but I believe they are going to be ones that are on Washington State University campus. A lot more cell towers, the coverage is much smaller. So it's just a way to look at tower density to kind of estimate how far certain towers may connect to a phone where others may have a very short range.
And is it based on that difference in towers that causes you to know that a certain type of tower report was used.
Yeah, it is a basic algorithm that uses tower density, and the only way to determine tower density is to have a list that has all of the towers, not just the ones that were used by the cell phone.
Okay. Do we have the list of the tower list that was used by Detective Mallory in developing that exhibit?
Detective Mallory stated he did not use a tower list to create this exhibit, so no, but I'm not sure how to answer that other than I haven't seen one.
Should it be there?
It is physically impossible to create this map without it.
If you had the logs from the CASBIZ program, would that give you more information about what was used?
It would. We would need the CASBIZ program as well. The logs are saving certain settings, and it's a JSON format, which is just a software language. We could load that JSON file into the CASBIZ program, and for the most part, we could replicate exactly what was done.
If I understand that, just turn it around. In order to replicate that and to see what was done, you would need a CASBIZ program. Is that right?
Correct, and preferably the same version that was used.
And you need a JSON file that was made by Detective Mallory. Is that right?
Correct, and depending on where this software program is, we would probably need the source data again because it may not be automatically linked. Anybody who did PowerPoint 10 years ago, you make a PowerPoint on one computer, you save it on a thumb drive, you go to a different computer, all the links are broken. It could create a situation like that. So you probably need the original source data as well, just to be sure.
What's the original source data?
In this case, it would be the AT&T CDRs and the cell tower, the regional cell tower list.
From that time?
Correct.
Okay.
Well, no, if we're trying to recreate this work, this is where it gets a little bit complex. We would need the exact AT&T tower list that Mallory used but didn't use, which makes it really difficult because AT&T updates these on a fairly regular basis. If he used a November list and I use an April list, the results could be different.
Why would the results be different and given the month of the video?
AT&T could have added or subtracted cell sites in the area, which would change the tower density. They could also reconfigure those cell sites, so maybe they point different directions. Given the rural area, 2 or 3 months, I don't think you're going to see much of a change, but it's always possible. So if we're talking about recreating this exhibit exactly the way it was, we would need not just the regional tower list, we would need to know which version of the regional tower list to use.
Is that generally why people in your field save their work?
We're talking best practices 101. We're creating a work product that is going to be used in a forensic nature, not showing how an extraction is done, not showing the source data that I use to create an exhibit. It happens, but for the most part, it's not perfect, especially somebody who is a subject matter expert in digital forensics. I won't say I haven't seen it, but it is rare.
Thank you. Let's move on and talk about the cast draft. Let's have you.
I'm sorry, Ms. Taylor, the passport report.
Draft. Have
Can
you,
I ask how much longer on this? Because we're 90 minutes. I need to give the quarter break. But if you're going to finish, in 5 or 10 minutes, that's probably fine.
Your Honor, I would say we probably have 15 or 20 minutes or so. If the court wants to do a break, we can, or
Yeah, let's take a recess. We'll be back in 10 minutes. Thank you. Relax.
Okay. I'm like, I still muted over here. Yeah, let's see. DB, if DB wants to come up, and you guys are laughing, but I'm like, I actually just got done using PowerPoint. When did I graduate from college? I had to use PowerPoints for college still. They didn't do no Google Slides or anything like that. Oh, yeah, we were still using old school PowerPoint. It's like 10 years ago. Hey, DB.
Hello there.
Hi. Thank you for coming up. Can you hear me okay? Uh-oh.
Hello. 1 second.
Hey.
I need to switch out my headphones.
Okay.
Okay, can you hear me okay?
Yep, perfect.
Okay, perfect.
Okay, make sure you use words like we're in 5th grade, not big words.
Okay. Let's see. Well, okay, so basically one of the major issues here that Ann Taylor pointed out is that they used the pen register, and that cell site simulation tool that they were using isn't like a software or anything like that. That $1 million truck that he was talking about has a cell site simulator in it. So when you drive around in it, they're trying to get that phone number to connect to that cell site. And judging on the strength of that phone number's signal to that cell site, they can kind of, it's like hot or cold, right? You either getting closer or you can try to send it off other towers as well once you capture it. And that can give you an idea of like where exactly that person's location is triangulated, if they have enough towers. But what she's saying is they already had that. Well, she's saying that they didn't need that because they already were doing surveillance on him at that time. So the search warrant they got to acquire the portable cell site was allegedly going to be used for a pen register, but they didn't. They used it for trying to map the routes, which would be kind of disingenuous in the search warrant.
Okay. Okay, that makes sense. But what is a pen register and why is that important?
So it's just like when they are trying to connect to your phone with a geographical return, like a longitude and latitude. So basically, they try to find the exact location of the phone. That takes a very high level warrant or like a very highly scrutinized warrant. Sometimes it takes a federal warrant. And a lot of the times the FBI will do it. So if they did get it and they did it here, but use that pen register that has a much higher level of scrutiny to do something else, that's an issue. So if you guys are familiar with the FISA warrant, it's there's been a lot of talks about them in politics, but basically that's like a anti-terrorism warrant, anti-foreign actor warrant. And sometimes the FBI will say that say there's a group of drug dealers and they're white supremacists. No relation, folks. I mean, we're not talking about that case, but so they'll say that that's a domestic terrorist organization, right?
Okay.
And they will end up using a pen register or a FISA warrant to do a wiretap on them because it has some type of national security implications. But that's kind of a simple way or like a more common way that people will explain, where a warrant would be not necessary for that level of detail that they're going to get back.
Okay, so the pen register itself is a physical device, correct?
The pen register is what they're getting from that cell site, and the portable cell site. So yeah, it can be an actual location, or if they have enough, like sometimes the actual carrier will do it.
Okay, what are they doing with it? That's so that's how they're tracking the phone.
Yeah. But they
Okay.
already knew where he was. They were trying to find his, and it's for the current location.
So they're trying to track him to find this particular phone number, but yet they were already watching him and had his phone number.
Yep.
Okay. So okay. All right. This makes sense.
It's
And
a
hold
little,
on a second.
it's a
Is
little
the court over here using a PowerPoint?
It looks like it to me, and they didn't even open it, did they?
Well, I'm just saying that guy's talking shit about PowerPoints, and the court actually has a PowerPoint up there.
Yeah, not cool, dude. Well, I mean, he is.
Okay.
I think he was trying to take a dig at Payne for using a PowerPoint to map something, which is kind of hilarious.
Okay, so after all of that testimony, what we come down to, and if I'm wrong, then tell me I'm wrong, is that they requested this warrant that only had the 48 hours, which is fine. That one's not an issue. They get the results of this warrant, and then they do the second warrant that they're asking to be able to use this mobile cell tracker, essentially.
Yeah.
And they don't need that because that is actually to try to track where this cell phone is. So they're driving around and they can tell where the cell phone is because now it's actually signaling off of them, and that's how they're doing it. So that's what they say that they're doing, but ultimately they already actually knew where he was because he was under surveillance.
Yep.
So the driving around and tracking this search warrant was not necessary, and they actually used it to try to map how he would have come and gone from the crime scene.
And that's not what it's used for.
But how would they be using it to try to map that?
Because they're driving the route and getting that cell tower to bounce data off of those towers with his phone signal, either with his phone signal or using any type of phone signal. They could just be having a cell phone connect to it, or if it's an actual cell site tool, they can manipulate all that to get it to bounce off the towers they want to, because it's provided by the people that are sending the data to it from either experts or AT&T themselves.
So it would essentially be able to track the way that he drove based on them doing that.
That's what Cyray thinks that they did, and that would cause issues with that type of surveillance or that type of tool being used for that, because it's only really used for when they need a location, a real-time location. And since that's not a real-time location, it could be the time of day, the temperature, the weather could all affect the real-time data. So they would go off like the historical data, the CDRs instead for that. That's like the forensically tested and like viable way of doing it in court. I see Susie's comment.
Well, that's what I always thought. I
said.
think that's where I'm confused at, is because they're saying they did actually know where he was, but I was not under the impression that they actually knew where he was. I thought that they had talked with the campus police, and then they said, "Oh yeah, we've got these over here or whatever," and then that was it. It was like almost like that guy was essentially like tipping it in, and they don't actually do anything with the information for a while. So this is where I'm kind of confused, I think, on this. I thought they were actually tracking to figure out where he was based on this phone number that had pinged off of the local towers.
So Cyray just testified that he's seen a surveillance report, multiple surveillance reports, that they were doing physical surveillance on him.
When?
I don't know. That's the first time I've heard that. Because they didn't have a cell phone tower expert before, so they didn't know like the actual steps that were taken to get to his cell phone locations and what towers he was hitting off from. And then once they got Cyray in, he was able to explain to them like what the normal procedures are and analysis that you could do, and be able to kind of dispel what the state was saying, or the state's theory of where the cell phones went, or the signal went. They did
All right.
physical surveillance in Pennsylvania too.
But I don't think
Uh-oh. T dropped off? Oh my god. Well, it's my channel now. It's really cool. Oh, sorry. What up?
Okay, I'm not normally somebody who kicks themselves off the live streams. I normally will talk on mute a lot, but that was a first. I don't know, I just hit the damn button and I apparently left DB in charge of everything.
Yeah, scary.
Scary. Scary. Okay, I still feel like I'm confused on this.
Yeah, I am too. Like,
So I just,
the surveillance thing is a little confusing to me.
well, yeah, because I don't know. I guess I'm gonna have to go back and try to figure that out because I don't understand. To me, they were not surveilling him. They did not know who he was. They took this phone info from the phones that were pinging it around the house and connecting over there, and then they went to go search each of these people, all these phone numbers, to find out who the people were. They connect from that to the fact that there was this white Elantra tip from over here, and then they get to Brian Koberger. But I guess what they're saying is that does okay. I think I kind of understand.
So
I think I kind of understand. Maybe.
I think the defense theory is going to be that they use what's called parallel construction to reverse engineer the case from the IGG, and they only looked at where they needed to look at to get the non-exculpatory information to be able to present in the PCA. They knew who he was and then got his phone number and then reverse engineered the case.
Correct. Okay, I'm picking up what you're putting down now. I got it. So essentially, they took everything from the crime scene and went to go find him, which is not necessarily reverse engineering. It's kind of what you do, but they're using call them tools that are still at this stage in trials a legal anomaly, if you will. They're not typically used. And when I covered the IGG stuff, this is one of the reasons I covered it, because it's not something that's in the legal standards yet. It's too new. So I'm thinking that this is kind of along those lines, and that's what they're trying to say is they didn't even bother to check all these other things because they were already just using this search warrant to just track him.
Yeah, well,
leaving out exculpatory evidence because they weren't even looking for it.
Yeah, so the theory that I've heard them kind of allude to is that the FBI did the IGG, and when they requested the IGG information that was in the PCA, the FBI then invoked a TUI process where they claimed sovereign immunity to the state subpoena, and because of that, they're no longer willing to testify to any of the IGG information possibly. And so that is kind of what they're referring to as reverse engineering, is that they have this information that they don't think is going to come in at trial. So they try to make a parallel case that works backwards from the suspect that they got from evidence that's not going to be presented or actually put in trial. So, here we go.
Okay, so I think I'm understanding now what you're talking about. I was kind of confused.
Okay.
Good.
And you're welcome to stay or go back to chat, whatever you want to do, whatever you're comfortable with. We're just hanging out anyway, so.
Thank you.
You run the channel now.
We are back on
Excellent.
record. This is State versus Koberger, CR 29222805. Everybody I identified previously are still here in the courtroom. Mr. Cy Ray is testifying. We are still on direct. Ms. Taylor, go ahead.
Thank you, Your Honor. Mr. Ray, when we left off at our break, I was about to talk to you about the CAS draft report.
Okay.
So we'll start there. Have you reviewed a CAS draft report in Mr. Koberger's case?
I have.
And From your review of that report, can you tell what records were relied on by Agent Balance to create that report?
That report would include, he had to have the AT&T CDRs, the full 6 months. A tower list to make some conversions that I'm seeing on the report. And also drive test data, which would be another form of source data. And then a mapping platform to ingest the drive test data into, to analyze it, to create these shapes that are then put into the draft report.
Okay, I think I have that. Do we have the same call detail records that Nick Balance used to create his draft report?
Yes, well, I believe so.
Do those records appear to come from the December 23rd, 2022 to AT&T warrants?
I would say primarily the second warrant from what I've reviewed.
And is that because the cast draft report spans the full 6 months of those records?
That is correct.
Okay, and those records, did those come from the second AT&T search warrant?
That is also correct.
Can you tell anything about the tower report or how the tower information was used by Agent Nick Balance?
The tower identifiers that are predominantly used, not exclusively, but predominantly used in the cast draft report did not come from the report AU. If there's a conversion that can be made, and someone would have to have the national AT&T tower list, or at least the regional list. And I would take information from the CDRs. I would look at certain columns in this AT&T tower list, and I could get certain identifiers that are now being populated to the cast report, if that makes sense.
Do we have a copy of the tower list that you believe was used?
We recently received 4 different versions. And when I say versions, they're just by month. And I believe we have August, September, November, and maybe December, or maybe it's in October. I'd have to go back. So far, I've only had time to look at the November. And from what I can tell, all of that appears to be accurate.
Would we need the October or the missing month to be able to do our work accurately?
It's a really good practice. I'm sure that's why the FBI included it. If I'm mapping records over a long period of time, like in this case, 6 months, I do want to see the different versions of the tower list to make sure that if a change was made within the network during that 6-month period, a tower I map in July may map differently in November. So it is important to have that data.
We have 4 of the 6 months, but not the other 2.
Correct. It would be helpful to even maybe see May, because there may not have been an update made in late June, early July. So May's would be what I would start with.
Can you tell if drive testing was done to create that cast draft?
Yes, there's images in the latter part of the report of around slides 100 and above. I believe there's a total of 4 images that were populated to that report that would require drive testing.
When somebody's doing drive testing, do you expect data to be produced?
Absolutely. Creating a work product that uses drive testing and then coming into court and testifying without the drive testing is no different than creating an exhibit like this and then saying, well, we don't have to produce the AT&T records that created this. The source data for drive testing is the drive test.
Do we have the drive testing that was done by the FBI to help create that report?
We have what I believe is the majority. There are some significant pieces missing. I can't say that those missing pieces exist and haven't been turned over, or they were erroneously not collected. I don't know which, but there are some pretty significant pieces that are missing.
I'm going to ask you some questions about that. But first, I want to know when you first saw drive testing data that was produced to us in Discovery. What did that cover?
I found a file in the Discovery, I want to say early December. that included drive test, but it was about a 3-minute sample that covered less than a quarter of a mile in a completely irrelevant location. So it added no value to my analysis at all.
What were you looking for? What time frame and location were you looking for based on the CAS draft report review?
I would expect significant drive testing around any location that coverage maps were being used in the CAS report. I would expect significant documentation on potential routes that this device may have taken. I would expect significant documentation on the crime scene.
You just told us that you think we have most of it, but there's some significant parts that are missing.
Yeah, and I want to qualify that just so it's really clear, because I understand it's starting to get very technical. There's over 500,000 lines of data that was turned over. So I'll make it clear, there's a lot of data that has been produced. I would say, in my opinion, looking at what's been produced, probably 2 or 3% is missing, but it's not the amount of data or the time of the data, it's the locations of the data. Some of the most significant locations in this case we're missing some data.
Those significant locations, have they been depicted or captured on the CAS draft report?
They have.
And tell me what those locations are. What are we missing?
I am unable to find any measurements along, I believe it's 270, the Moscow Pullman Road. If you drove the most direct route from Pullman to Moscow or vice versa, pretty much as soon as you're leaving Pullman to the time that you arrive in Moscow, we are missing that entire stretch. If there's ever been a case that we need to look at, what does it look like when a phone travels from Pullman to Moscow? This is probably the case. We have the neighborhood around the crime scene, but we don't have the crime scene. Normally that wouldn't be too terribly significant, because if it's a flat area, there's not a lot of vegetation or mountains. You could probably interpret the same. The location of this crime scene is very unique because it sits on a mountain. Part of it is shielded by a mountain. There's a lot of other big, thick, dense apartment buildings there. Your phone is going to behave differently inside of that residence than it might on the road behind the residence or in front of the residence. I can't find any drive test data that actually encapsulates any part of the property.
You talked about the device that helps do the drive testing or that captures the data while you're doing the drive testing. What's that called again?
It's a drive test scanner. The most common one used in law enforcement is created by Road and Schwartz, that same company I referred to earlier. I'm familiar with the hardware that the FBI uses, and it is a Road and Schwartz scanner.
Is it called Gladiator?
Gladiator is the company that sells the product to the FBI. Gladiator actually buys this product from Road and Schwartz, and it does what they call white labeling. So they buy the hardware from Road Schwartz and they kind of slap their sticker on it and they put their software in it, and then they sell it to the FBI. But ultimately it is a Road and Schwartz piece of hardware.
And once you have that piece of hardware, once you have this device, does it just work forever, or is there anything that has to be done to make sure it's working properly?
It is a technical piece of equipment that takes measurements. It is required to be calibrated. The best way that for probably everybody in the courtroom to think of, if we go a little old school, is the old breath test. If you had a DUI and law enforcement couldn't produce the calibration records of the breath test, it was really problematic. Similar thing here. We want to see that the device is calibrated. In this case, it's really important because, keep in mind, I reviewed thousands of these drive tests over my career. There is a significant gap that I believe there's something malfunctioning in the equipment, or the operators are just not paying attention. I can't tell you which one it is. So in this case, the calibration records to show that that device is functioning properly are really critical.
Do we have those calibration records on the device that was there more than one device used?
There was actually 2 devices used.
And was this drive test done on just one day? Is this a one-time shot?
No, I think maybe 5 days total that I've seen drive test data collected.
Okay. So now let's talk about the calibration for this instrument or this machine. Did we get records for all the machines that were used by the FBI in this case?
We got the calibration records that were taken prior to the use of these, of the samples. It'd be really helpful to have the calibration records after the use. So we kind of need to bookend those because we know that it left Rochefort's factory in October and everything was working great. When it came back, we don't know when it came back, and we don't know if it was functioning properly when it came back. It's not uncommon for there to be errors. If I saw a report and said it came in and it had 2 errors, it's not the end of the world. The sky doesn't fall. You have to get into the documentation to see what those errors were. Normally, the device kind of self-calibrates itself. If you know what you're looking at, the major concerns that you would see when calibration is off, it becomes very obvious because results are really flawed. That's where I have a concern in this case is we have what I consider a significant chunk of data for specifically a location where the instrument is running. There's no doubt it's functioning, but it's not properly collecting AT&T data, which is concerning as to why.
Because there were multiple drive tests done, and you talk about bookending these calibration reports, would you need to bookend all of the time that the drive testing was done with these calibration reports? And what I'm saying is if there's something done in November and then drive testing done in December and then more drive testing done in January and then maybe some in March, do you need the bookend calibration reports around each of those drive tests?
You would. To date, I haven't seen any drive test data, I believe, beyond January 5th. And I'm not sure the time zone, so maybe it could creep into January 6th. But if there's any drive test data after the first week of January, I'm unaware of.
Okay. So in our case, which months are we missing?
For the calibration,
Yes.
whatever the next calibration, the FBI would choose when to send these devices in. So whenever that next calibration report was generated for these 2 devices.
On the calibration certificates we have, I think you told us that after the maintenance, it went back into service and passed inspection, was functioning properly.
But when it came in, it didn't have multiple errors, but when it went out, it was functioning properly.
Is that why you need to see the next one on the other side of the drive testing?
That is correct.
Okay. Now, when we're thinking about the data that, the drive test data that we have that's missing some significant portions, could it be because the machine wasn't working right all the time they tried to do drive testing?
Yes.
Okay. Is it also possible that the FBI agents using this machine weren't properly trained to do the drive test data or to do the drive testing and collect data?
I know of the 2 FBI agents from prior lives. I believe they're properly trained.
So we're looking at either the machine itself isn't functioning properly, or could that data have been pulled out of what we got?
If we're talking about possible scenarios that would cause the shortcoming of data, maybe it was never captured in the first place. I can't speak to that. The machine erroring, at least during one portion of this drive test, I've seen similar errors before. I'm pretty sure they had a small period of time where it had been a very busy day and it kind of gave up for a little while, like any computer will, and needed to be reset. Could things be extracted and us not know? It's always possible. I can't rule that out.
Is the missing data important to you to fulfill your duties in Mr. Koberger's case?
I don't recall when I got involved in this case on the day where I could actually start looking at evidence. I've had a concern since the very first day I saw the cast draft report that there are significant errors in drive testing. It was before I even saw the drive testing. I can look at the coverage areas and I can tell you they're wrong. So yes, it's not a concern that they're wrong. People make mistakes. We can fix things. It's a concern that I still don't have the source data that any expert, not just myself, but anybody could sit down and look at and say, okay, I see what's happening here. Here's how we fix this. Unfortunately, that mistake has a ripple effect, and I'm seeing multiple errors that are happening as a result. So that's why this data is important, is we've reached a point that we need to determine, is this just human error? Is this accidental? Is it intentional? Is there other things at play here that's changing this narrative to where there's clearly some manipulation of the original data?
And having that data, will that help us answer that question?
It's the only way we're going to answer that question.
All right, I have just a couple of other questions for you, and I'm going to depart the cast report and the drive test data a little bit. Except, as an investigator or as a person doing an analysis of this case, did the drive test data tell you where a phone traveled to indicate other investigation that you should do?
Technically, the call detail records tell us that. The drive test data help us become more accurate with that. AT&T is one of the best companies in this particular situation to show device movement because we get a constant connection. So when, and I will emphasize, when all of the data is mapped, and I'm talking about the CDRs, we can get a really good idea. Hey, a phone traveled north for 10 miles and then it traveled east. The drive test data would actually allow us to replicate and recreate these tower handoffs that we're seeing to come up with that first theory to now we can say, in order to do this and hit these towers in the sequence that it did, it has to be driving on this highway. And then when it went east, it most likely turned onto this highway. So the drive test data helps us get very specific with what the CDRs mean.
As an investigator in performing an analysis work done in this case, when you have the CDRs, the call detail records that tell you where a phone's been, is that useful in directing your investigation to what other evidence might be out there, like videotapes?
Qualify my answer to it because I'm not sure if you're asking specifically for this case or in general. Yes, you map all of the data. And especially if you're going to justify 6 months worth of data on somebody's cell phone, you map every single connection that there is in those records. From what I have reviewed, the FBI mapped 6% of the data that came in. Mallory's testimony and what I've seen through here, he was up to about 18%. So by either standard, more than 80% on both accounts were never mapped or accounted for. And I'm not talking overall from every single day for 6 months. I'm talking about the timeframes that are chosen. So for example, this time period that's represented here is where I'm getting the 18%.
And that's the 48 hours?
This is specifically from 2 a.m. to 6 a.m. on the morning of the 13th, arguably the most critical time period of this entire investigation. They mapped a handful of connections. When I say handful, they mapped 18%. When you add the other 82%, it tells a much more detailed story. When we put the drive test data on top of that, you can get even more refined. But to answer your question on any case, that's this case, on any case, and we teach best practices. We've established best practices going back to 2008 in law enforcement of what you do with this type of data. It is a terrible practice to justify probable cause for this very detailed call detail records that give breadcrumb-like trails for individuals and then not map it. We justify an entire probable cause statement saying we have to have this. Not mapping it and then making decisions and work products with leaving that out is extremely problematic.
Last week, we received some additional records that Detective Mallory found when he was preparing for his testimony on this mission to Compel. Have you had a chance to review those records?
I have. A couple of them are very technical, so I'm not going to say that I've mastered them yet, but I have a good idea of what was provided and what it means.
Based on your, I guess, not as thorough as you'll do review of these records, do you have a sense as to whether these records matter to us and what we're doing to defend Mr. Koberger.
Given the timing of these records, from what I can tell in the emails that were produced by Detective Mallory, these records were generated on the 23rd of December. It's when everything started with probable cause statements. If I had to pick a time when the wheels fell off the wagon, that's the date. There are statements and there's assumptions made in the records that will never be supported by the data. What it's claimed to represent.
Sounds like those might be pretty important.
Claim will never be supported by the data. There's a lot of claims that are said in these emails, and even the name files of the records are problematic. It does not represent what it's claimed to represent.
Sounds like those might be pretty important to us defending Mr. Koberger.
I could give examples, but I know it's a very technical thing, so I'm not, it could be extremely impactful to either side. I'm not saying just in defending Mr. Koberger, it could be extremely impactful in prosecuting Mr. Koberger. The problem's the problem, not what the data helps or hurts.
The content of the data, though, is it helpful to us in representing Mr. Koberger?
It absolutely is helpful. Everything that I've seen to date is concerning to me because it's exculpatory. And I need to clarify this. When all of the records are produced and the dust settles and I have time to review it, I reserve the right to say, no, now I'm seeing everything. Here's what I'm seeing. Because of the piecemealing of the data, because of the missing data, because of data that I'm reviewing that is incredibly inaccurate, everything that is missing is absolutely in the benefit of the defense right now. There's other reports that I believe are missing that I can't tell you are in the benefit of Mr. Koberger or in the benefit of the state. If I was contacted on December 1st by Moscow Police Department, there are things I would have absolutely said, you get this today, do not hesitate, and especially come December 23rd. Not because of who it's helpful for, but because those documents are the only things we're going to get that's going to be able to allow us to interpret what it really means. When we don't get those documents and we piecemeal things, it creates this narrative that is very harmful for the defense's case. As I've got more documents, I'm finding it's not harmful for the defense's case. There's a lot of misstatements that have been made. So yes, to your question, to date, it is very helpful for Mr. Koberger. I reserve the right to change that opinion in 6 months, depending on what type of documents are released and what's out there.
Fair enough. I need just a minute, but I don't think I have any other questions.
Thank you.
Mr. Ray, thank you. I don't have any other questions right now, but hold on. The prosecutor might.
All right. Ms. Taylor, Ms. Jennings.
No, I don't have any questions at this time.
All right, may this witness be excused.
He may, Your Honor. Thank you.
All right, Mr. Ray, you're free to stay. You're free to leave if you like.
No questions
Thank you.
from the prosecution.
Yeah, very interesting. I suspect they're going to file probably a sealed motion or something soon then.
Yeah.
Good witness.
Your Honor, we do not have any other witnesses. We have argument for the court.
Okay. Let's go ahead then.
Your Honor, what I'd like to do is I'd like to start with Ms. NASA. She's going to cover one of the requests specific to the grand jury subpoenas, and then I'll cover the rest of this morning's argument.
Okay, thank you.
Your Honor, to facilitate this argument on this point, I am going to hand you defense exhibits A and B that were submitted in our records for today. I want you to be able to look at them while I'm talking.
Okay, thank you.
I'm actually
As of
surprised the vet
today,
didn't
there have
have
been at least 50 federal grand jury subpoenas that have been issued in this case. Exhibits A and Exhibits B are an example of copies of grand jury subpoenas that we have received out of those more than 50. And what I didn't provide to you that goes behind that what we got with those is the subpoenas include attachment A, which explains what is being subpoenaed. And then what has been produced is the responses to those subpoenas. And in some of the subpoenas, we also have the certification by the person who has produced the records in response to the subpoena. Some of them are missing. We have asked the state to produce all of the subpoenas. And their response is that they are not in possession and control of those subpoenas, and they do not intend to use the subpoenas as an exhibit. And we have not justified why we need those subpoenas. And for those reasons, they are not going to produce them. I'd like to begin by saying that as it relates to any argument that the state is not in possession and control, rather than beat the dead horse on that issue, Idaho Supreme Court came down in 2023 and made it crystal clear that anybody that's acting on behalf of as an agent of the state puts those records in the hands of the state, and they need to produce them. State versus Pendleton, 2003. The other thing is that in terms of the state arguing that they are not going to use a subpoena as an exhibit, that is not in and of itself a defense to not produce a document to us. We have a million reasons why we need to look at documents. We understand that out of the 51 terabytes that have been produced, that not all of that is evidence that's going to be coming for the court or the jury, but it doesn't mean that they aren't material or exculpatory. The subpoenas, based on reviewing the records, are in the hands of basically three agents. There is an FBI forensic agent by the name of forensic accountant, Michael Douglas. There's a special agent, Travis Shirley, and there is another agent, Mary Tyndall. These are the three agents that are receiving the subpoenas, reaching out to the providers that they're serving and asking for the documents. For the court to understand why we need these documents, I want to tell you what we're doing with discovery and timelines. There are more than 100 search warrants in this case. There are more than 50 grand jury subpoenas in this case. You've heard all kinds of information about the probable cause affidavit and the timing of that. Timing in this case for the defense is everything. So we are creating timelines that put in the dates of affidavits of warrants, the information that's received, and the date that it's produced. With subpoenas, when we don't get a copy of the subpoena and all we get is the warrant or is the subpoena return, we don't know the scope of what the state has asked for. We don't know the date that the subpoena was served. And in some of them, we don't know that there is a certified return. So we can't take our timeline on warrants and our timeline on the probable cause affidavit and our timeline on everything else that we're putting in there and interlay the subpoena information that the state is getting. And we are desperate to find out the timeline in this case and when the state knew what and when. There's no question that motions to suppress are coming. Motions to suppress are coming on warrants. And whether or not those motions to suppress are based on Frank's material because misrepresentations are made depends on the timeline. So if there's a representation made in a warrant that things happened in a certain way, if we are able to look at the timeline and say, we know that the state knew this when, that gives us an answer on whether or not the suppression issue includes a truthful statement in the affidavit. And if I'm not making sense, I want you to tell me to clarify that. But we need to know the timeline of all of the evidence in this case and when the state knew what it knew, or why certain things were being looked at before Mr. Koberger's arrest or well into late in the year in 2023 related to the victims, and try to piece together, is that something that the state is still seeking because they're pursuing the alternate suspects that exist in this case? There's so many things that we're trying to understand. So what we're asking you to do is enter an order compelling them to produce the subpoenas. You see that they had at least 2 in their possession that they possess, and it will clarify it for us. And we will be able to create our timeline and put all of these things together and know when and why the state was doing these things. And just to add one other component, you know, you're hearing about cell phone records and cell phone records today being produced on warrants. Well, there were several sets of cell phone records that were produced pursuant to a grand jury subpoena. Still not clear to us why warrant versus subpoena, and they're different providers. And some of it's for phone numbers that we have to figure out who those phone numbers are. But all of this information is critical and material for us to be able to do the case, to do our work in this case. So I would ask that you enter an order to compel, and that way the state has the ability to take that to the FBI agents and say, the court has entered an order, we've got to produce the subpoenas, and we'll get the subpoenas. And to the extent that the state may stand up and say, you know, we've got this TUI demands, we've got to deal with TUI. I just want to make it really clear for the court that TUI is not an obstacle. TUI is a hoop to jump through. The code related to 28 CFR 16.21 specifically states that the purpose of TUI is not to prevent federal agents from giving states discovery in a criminal case. Purpose of TUI is because these federal departments want to know when certain records are leaving their files. Understandable, but it's not meant to keep us from getting records that we need in this case.
Thank you. Response?
Well, simply put, we can't give over what we don't have. And we do not have the majority of these subpoenas. What we do have, we've turned over. I reached out to the U.S. Attorney's Office. They advised they're not going to provide.
What? Why?
Because they don't provide subpoenas. You know, just like most grand jury material, it's sealed and not typically provided.
Not typically,
Not provided.
but even with a TUI letter, that wouldn't give it. We provide, they wouldn't follow that.
We have not, I'm not sure. But beyond that though, even if they were to provide it, I still don't understand how this moves the needle one way or the other. You can tell, I've detailed, there's 71 federal grand jury subpoenas. And in my response, I've detailed exactly what they were for and what records were received so that you can get the scope of what was requested from the actual records. The piece of paper that was given over saying, give us these records is all they're asking for, but they have the records. They have the important part of this.
So they have the timing based on the subpoenas
Off of
that
the
you
records,
provided to the defense.
off of the records provided. You can tell the scope as well as what they're for. And I've detailed exactly what they were for, the scope, in my response.
Any response?
Judge, I wouldn't be wasting the court's time asking for this if the questions were answered based on the state's response to our request for discovery. Timing is critical on when a subpoena is served, what was the scope, then we can look at the documents to see if they are actually responsive to the scope. And knowing the timing of when that was served versus when it's produced to us is different. And again, I mentioned some of these things are pre-arrest of Mr. Koberger, and some of it is in the middle, and some of it is, frankly, months after the fact, if not a year after the fact, where they're looking for things related to the victims.
So can I ask a question? Because Ms. Jennings just said that that the dates, well, all the subpoenas that were provided to you, 71 subpoenas, and each one of those had the scope of what the request was in the subpoena, and that it would be dated. No,
That's not true.
that's
That's
not.
not true. No. There are all kinds of different records and different methods that the people that were the businesses and the people that were asked to produce the records produce them in different form. I do not know when they received the subpoena, the timing of it, and I do not know for all of these what was the scope of what was asked for versus what was produced. I do know what's produced, but I don't know the timing. And the answer of the date discovery provided, which is in Exhibit 1, that the date that a discovery is provided to us doesn't answer the first two questions that I have, which is the timing of when they asked for it and the scope that was stated in the subpoena of what they asked for. Some companies were asked probably for a certain number of months, and they didn't have records that were responsive to those number of months, right? Because when the state's doing this investigation, they're not necessarily knowing exactly what records exist. So being able to be specific is important. And I want to touch on this issue of it. It's not in their possession. I get that. But you have complete control over what evidence is going to be coming into this case with your orders. You make it crystal clear, produce it or it's not coming in. That's the first level of sanction. And then we can just get going from there. Something that's destroyed, you can't produce that, there's going to be a spoliation instruction. Something that we keep repeatedly asking for and it gets past time, we're going to knock the death penalty off the table. You have control to get these issues that we're struggling with fixed by saying, this is my order, produce it, or there's going to be a sanction.
You may be overestimating my power.
I think you're underestimating your power.
I have a good sense of where my power starts and ends. So I don't know. I mean, there's so much discovery that has been shared. Are all of these 71 subpoenas, have they been provided to me at this point? Because I don't think I've seen them.
They went through a federal grand jury. So this is, we haven't seen anything in terms of the grand jury testimony, transcripts. What I have surmised based on my federal practice, because I spent about 50% of my time in federal court, is that they used a federal grand jury as an investigative tool because the FBI is partnering with them. That makes complete sense. These subpoenas are in the hands of the 3 agents that I gave you the names of. They haven't come through you. They're in the hands of the agents. And so it's a matter of them just gathering the records that those agents have in their possession and providing to us. And it helps us create this timeline in a case where discovery is being given to us as if we're living in a snow globe and it's just swirling around us and we're constantly having to put it together. So, you know, you've asked us several times, what can I do to help you guys get your work done? This is one of those things. Let us see the subpoenas so we can overlay this in our timeline.
But you just want the subpoenas. You don't necessarily are going to get the response.
We have the responses. We have the records, but what the records don't tell us is what was in the subpoena. It's like a warrant return. What is a warrant based on? It's based on an affidavit.
So
Right.
this is what you want, the paper that says,
And the
this is
exhibit.
what we want.
And the exhibit A that's attached to that, which I didn't give you a copy of exhibit A, but exhibit A is attached to each one of those. And then it specifies to the company, you know, you're looking for phone numbers that are this, and this for these dates. You're
That
looking
doesn't have the date on that, when
in
it was served.
that, those subpoenas tell us, we know when they are served because it comes back with a date on it. And then,
Right.
and then the attachment A has the scope of what they've asked for. What we've gotten is the documents without, it's like not having the affidavit to the warrant return.
Okay. I think I understand that. And I'm gonna go back to Ms. Jennings and just clarify. What have they been given already?
They have been given records for, in response to all 71 of those federal grand jury subpoenas.
Do they have dated on there? Because that's,
Many of them do. You can see that from the description of the conference that I provided to the court. I can't say that all of them do, but many of them do.
well, that's
They're
very
right.
important, apparently, for the defense, as Ms. Mathis said that, timing is everything here. So I think that's what they're really after. That's one of the things they're after is just the time frame.
We can seek to inquire as to, because what I keep hearing is they need to know the date that these various companies received the subpoena. We can still inquire. It's provided on a lot of these,
Right.
but on the ones we're missing, we can attempt to inquire and find out the date that it was served, and we can still do that without providing the piece of paper.
Well, besides the timing, what's the relevance to this this scope that was requested? And you know,
What's the relevance? But
Yeah.
we're not relying on any of these.
I know, I don't
Right.
think you're, what do you think they think is relevant?
Yeah, for sure.
Okay. Mr. Thompson, so what is the relevance? But aside with the timing, okay, and the scope.
Judge, I'm not going to give you the specific date right now in open court on one of the subpoenas, but they used a subpoena to get one of the most critical pieces of evidence in this case. And they know that.
Okay,
And they are going to use that.
Response.
it's something that I don't know about.
Well, I mean, you probably,
I've been-
you do know of it. It's in the probable cause affidavit.
Okay, thank you. All right, Ms. Jennings, you
What I
want?
can tell you is that for the majority of the stuff, we did state search warrants. And we've received many of these records that way.
Okay, thank you. All right, enough with that. Thank you very much. Appreciate it.
Like enough with that.
Maybe it's a time to, well, let's see, where you still have your argument. How long do you think?
Your Honor, my intention is to talk about the law that governs discovery requests and ask you to compel certain things. I'm going to go through our 4th request. I'm going to tell you a few things that we have, and then I'm going to tell you why you ought to order that the state give us the rest of it, how it's material to us, and how it's in the possession of control of the state. And I'm going to do the same thing. I would say I'm going to talk 15 minutes, maybe.
Okay, great. Go ahead.
Thank you. Your Honor, then where I want to start is with Idaho Criminal Rule 16 that governs discovery. 16A directs which things are mandatory disclosures from the state. Those are things I don't even have to ask for. And those are items that the state has possession and control over that would tend to negate guilt or reduce punishment. 16B is the portion of the rule that governs when I request items in the course of my preparation of the case. And I would have the court keep in mind 16A and the prosecutor's responsibilities and Idaho Criminal Rule 16B and the discovery requests that we've made and what we have not received. We've asked for documents, we've asked for reports, we've asked for qualifications and summaries from experts, and we've asked for media that's been gathered in the case. The court can order other things that we ask for based on the need of the case. I would remind the court of the case that Ms. Massa just talked to the court about, State versus Pendleton. I know the court's familiar with this. This is a good case because it's recent and because it takes the time to define what's material and what's within the possession and control of the state. We need to think about our motion to compel in the order we are requesting from you in the context of what's in the possession and control of the state. Your Honor, the State versus Pendleton case says that any law enforcement, and this includes the prosecutor's office, it includes their staff, it includes any law enforcement that worked with them on the case. In this case, you're looking at Moscow Police Department, Idaho State Police Department, Idaho State Police Forensics Lab, and FBI agents, to name a few. So what those entities have and have developed are within the possession and control of the prosecutor. So with that backdrop, I want to run through our specific requests and talk about what we need. You've heard testimony, and so I think you know why these things are material, but let's go over it again. Starting with the fourth motion to compel, Ms. Massoff went over 1A, the grand jury subpoenas. I'm going to leave that argument alone. She did a fabulous job with that. When we're looking at 2A, this all comes from the defendant's 11th supplemental request for discovery. 2A is the video on King Street. Your Honor, we began asking for that a long time ago. We have it in full, so we don't have to talk about that. We received that full for all of the hours and days in question with both audio and video on 510. So we can mark 2A, item 219 off of our list.
219.
219.
And there, I've gone through pages and pages and pages, so I think I really appreciate you being very specific about, you know, what you have now and what you will still.
Okay. Good, because it's the only way I can keep track of it.
Yeah, well, same here. Thank you.
You're welcome. Your Honor, item 2B in our fourth motion to compel is item 224. That's the CAS biz log. And this one is rough. The court heard last week Detective Mowry say, I don't have any of those, except I found these other items that we'll give you now, which were not Mowry's CAS biz logs. The hard part for us about this one, Judge, and I have to make a record. I think you can order them to double check, and I'm going to ask you to order them to double check. But the hard part of this for me is that on January 9th, we asked for these CAS biz logs. And the response was from the state was CAS biz does not produce logs. And that's just not true. It does. It's capable. It produces logs. You've heard that in the testimony. Then we filed our motion to compel and explained we have an expert. We know it produces logs. We're going to bring them. And the response was the working files were not saved. We received that response on April 23rd, 2024. And then on May 10th, we got a little bit more explanation about default settings were used and optional session files were not uploaded. This is really, really difficult because of the varying answers that we've received. The court's heard testimony from Mr. Ray about how important these logs are to know what was done. This is really challenging. We can't recreate what Detective Mowry, who testified before the grand jury, did, unless the court orders that we get the tower list he used and we have the Cast Viz program. And quite frankly, that's what we want. We need to see how this work was done. This is important work. I'll tell you the other thing that's really troubling and frustrating, aside from the other files that we received in preparation for motion to compel, is these screenshots that we got for the first time last week when we're on a motion to compel and have a witness before the court. We didn't have those screenshots that Detective Mowry had created before. The only thing we had was Exhibit 48 that was given to the grand jury, which is a video that was handed over then. So this is really problematic to be told these varying things and then have something else produced on the day of testimony. Your Honor, we are going to request that the court order that we have the tower list used by Detective Mowry and access to the Cast Viz program. So our expert, Mr. Cy Ray, can go through and see what Detective Mowry did. That it's imperative that we be allowed to do that. That's the only way to recreate what Detective Mowry did.
It seems to me he did acknowledge that he just went back and provided this a day or 2 days before he testified that he found this additional information. So I'm thinking that the state got that information and had provided that to you. Now, we also heard a lot of the quotes missing pieces today, which I'm guessing that FBI, Mr. Valance and Detective Mowry are going to go back through that and see if there's something else. At this point, I'm assuming that, some things may have fallen through the cracks. I mean, it is very complicated. There was a lot going on. We have some time before trial. I just hope that everybody goes through their computers or their files or whatever they're going through so that it's complete. So what I've been watching over the last 2 months is that there have been supplemental responses to the defense. So things were coming in. They were waiting for information to come in so that they could provide that to you. So that's why I don't want to go backwards either. I just want to make sure that we are addressing what you don't have and what actually you're entitled to. So that's the tower list. I mean, I don't know anything about tower lists, so I'm learning about that. I don't know that Detective Mowry addressed that, really, maybe, unless I missed that.
Your Honor, I believe he testified last week that he used the tower list that was contained in the AT&T record that he received. You heard today that that doesn't exist. And you heard today that the tower list was something different that he used. And that tower list had once that was entered, there was a selection on the program to do tower density as well with that.
Like I said, it's confusing.
It is. It definitely is.
We'll keep going now.
Okay, thank you.
You want the tower list?
Yes, I think I'm getting there, but I definitely want that. I want the one that Mowry used to do his Cast Viz work back in May of last year. That's the one I really want right now, at least at this juncture in the documents right now. I do want to clear up though, when we talk about what Detective Mowry found last week when he was preparing to testify, those are emails between him and Nick Valance. Those are JSON files from Nick Valance to Detective Mowry. None of those things that he found, other than screenshots like the exhibit that you have of his map with the different size towers depicted, other than those screenshots, the other things he had came from Nick Valance. Those were not his logs that he found. Those were not his towers that he found, just to be sure that those are still missing. to the extent they exist, and we can't recreate what he did without the list and program. Moving on.
Thank you.
Moving on then, Your Honor, is item 226. That's called the Hemisphere Program, also known as a timing advance report. Your Honor, this is one of the troubling areas again. The first response was that the records do not exist. There were letters exchanged between the state and us asking for more information. In one of the letters from the prosecutor, we were told that this program was not used in Brian Koberger's case. And then we filed a motion to compel. And we were told that the state was not in possession of the timing records. And then the next supplemental response in May of this year, just a couple of weeks ago, was to tell us that there's some new certified records from AT&T that we're going to get. I don't know what those are. I can tell you that these timing advanced reports were asked for from AT&T, from Verizon, from T-Mobile, and another cell phone company. In both of the early AT&T warrants, we called them the 48-hour, and then the extended warrants back on December 23rd, 2022. We don't have those. So I just want to make a record that I need to know what happened. Moving on then to 228, item 228. That was trying to understand what was relied upon for the second AT&T warrant. And we heard quite a bit today from Detective Payne about what he relied on for that second warrant. And that had to do with what was produced and analyzed in the first warrant. However, we asked for some emails and some communications. We know about some text messaging that we've received, but we don't have written correspondence, emailed correspondence, exchanging information, just the text messaging. So we want all of the email communication between Payne and Balance, well, between anybody from Moscow PD and anybody from the FBI. Your Honor, item 229 is the MAID data. I would say we received a disclosure, and I think we got that on either 510 or 517. And I'm going to need some time to have an expert help me out with that. I don't know if that's complete. I also know that in the fifth motion to compel, there is information we've asked for from Babbel. That was a program that was used to help decipher some of the MAID data. And we're going to talk about that in a minute, but that one's yet to come. So I'm going to ask the court for an order compelling the state to give me all the MAID data. They may have already complied, though. Their intents to comply, I can tell you that.
What does that stand for again?
Mobile advertiser. Let's see, I've got it in here.
Okay, I'm glad.
Identification number, mobile advertiser identification number.
Okay, thank you.
You're welcome. All right, Judge, we are now talking about item 242, the CAST report. The history of this is we came to the court asking for the CAST report, knowing it was relied upon last year, and the court ordered that we receive it. We received one that was stamped draft all over it. You've heard testimony about that today from Mr. Ray, and it's not a final report. And we knew that when we got it. We asked for that. We asked for the analysis behind that, and we haven't received that. We were told on February 23rd of this year that the state will provide this by March 31st. Well, March 31st came and went, and we did not get it. So on April 23rd, the state said we still don't have it. And then on May the 10th, the state responded to this request and said that because we provided additional information, Mr. Koberger's alibi, they need more time to do work on this CAST report, and they'll get it to us later. Your Honor, I think you ought to order that we get the cast report. And I think you ought to order that we get everything that went into developing this and we get the analysis that they made from that. This is particularly troubling. Their response, you told us something, so now we have to go reconfigure the cast report. Let me tell you why that's troubling. Item 243 is our request. Give us a list of everything Nick Valance relied on when drafting his cast report. And we were told Nick Valance relied on the call detail records from AT&T. Nick Valance relied upon tower records. And he relied upon the drive test data. Nowhere in there does it say, if you tell us anything about the case, we need that to rely on that too. These are records that exist. These are tower lists that exist. They go into a program. You do drive testing to understand how the device interacts with towers, and you create a report. So we're asking the court to order that we get the cast draft report, we get the full list of everything he relied upon, and we get the analysis of what does this mean.
So another clarifying question, maybe. So I listened to the testimony today, and that it sounded like a cast report was provided, but maybe it wasn't complete. Is what Mr. Ray suggested. But I think that maybe I'm guessing, we're assuming that the state provided what they had, but it maybe they're still working on it. I don't know. But didn't you get initially what they had as they characterized as the cast report? So when you say, I mean, we have problems with language, I think, especially when we're in this area, technology. And so we might be just going back and forth like this without really understanding what we're asking for or what we're providing.
Let me see if I can clear that up. The testimony today, when we had Detective Payne on the stand, when we talked about what did you rely on to get the second AT&T warrant, he said that there was something that Nick Valance produced and that the prosecutor had it, and he thought it was the cast draft. And then you heard from Mr. Ray, who said, I've seen the cast draft report, and maybe it's something different that Detective Payne looked at. It wasn't this big long cast draft. The cast draft report, and I'm calling it draft because it's stamped draft. I knew it wasn't final when I received it. We got that because you ordered that the state give that to us last summer, last July. So I had this draft. I knew it wasn't final. Ms. Jennings knew it wasn't final. We've talked about it. We believed that we were going to get the final report by March 31st. We don't have that yet. It's the final report that we need. You also heard from Mr. Ray talking about the things that are mistakes in the cast draft report. These reports go through a peer review process, and they can look a little different when they come back out on the other side. Usually not vastly different, but they can. They go through their process. It's that final product that I need that. I need to know everything they relied on to do their work. I need to know what this draft report is going to look like. The court should know that when we get to trial, likely Agent Valance is going to come in and talk about his cast draft report. He's going to be an expert in the field and talk about what he found and why he found and what he relied on to do that. I'm going to come in with an expert that's going to explain what his work did. Now, if the work aligns and Nicholas Valance and our expert aligns, well, that's just going to be shorter. But right now, it's definitely not looking like that. It looks like they're going to have their side, and we're going to be talking about what the data shows. So what I want is the final report that we were told would be available by March 31st. I need time to work on it.
Sure.
What I want is a full list of what was used to create that report, what was relied on. I have to be able to see if I can recreate that. I have to see what was right with it and what was wrong with it. So I don't have those two things, right?
Is it possible that it's just not completed?
It
It's
is
a final-
possible.
A final report?
It is possible, but I need you to order that come to me. And I don't think Ms. Jennings doesn't want to give it to me. But if you order that I get it, then I'm gonna get it a lot sooner, I think. I'm not saying that Ms. Jennings is sitting holding it behind her back. I'm saying I don't now know what's going on. The FBI told her it was gonna be in by March 31st. We hit our deadline to disclose our alibi. And all of a sudden now they need to redo something in the report, which shocks me because of the things they said that they relied on were things that already existed. So now I really need to know what they're relying on to do this report, and I really need to see the analysis, and I really need to see the final report.
Sure.
I have to react to it.
Since we're talking about this, Ms. Jennings, do you want to just respond to that? Whether or not this is still a work in progress or what's going on?
Right, Your Honor. As I know right now, that report is not in its final form. And it has gone through a peer review process. My understanding is it's still in that. I have been told that yes, it's not a matter of redoing anything, but as they receive additional information, they just want to double check their work. They want to make sure that when they get the final report, it's accurate. So we are still waiting for that final report to ensure that it's accurate. And as soon as we receive it,
I'm sorry. You have a time frame for that?
um,
I told you when they expect to be finished?
I don't have a final time frame. They originally told us it was projected to be completed by June next month. So I'm hoping to get it within the next month.
All right, thank you. Appreciate that. Sometimes it's easier just to sort a particular issue at the same time.
Some of the hot ones, it might be, Your Honor.
Yeah.
Your Honor, I do think we have the regional tower list now, so I think we're good with that. On item number 244 and 245, we have those documents now, so we're good there. Moving then to item 248. This is the drive test data, the mapping data. The court heard pretty extensively that we've received this in two places. We've received some early on, and then we received a lot more recently, but it appears to still be missing some. Asking the court just to order that we receive the entirety of all drive test data that was conducted by Agent Balance or anybody from the FBI. $249 is anything that exists after January 6th of 2023 for the drive test data. That's number 249. And so I would ask the court to order that to the extent that it exists. Would ask that it be ordered to be produced. Item 250 is the training and certification records for Nick Balance and Sean Kennedy relating specifically to the use of the Gladiator or the GAR. That's the item used to conduct these drive tests. Your Honor, I think that we gave the court a transcript of testimony of Nick Balance that occurred within the last year. And that transcript had highlighting on it, so the court didn't have to read the whole thing, but to look at how many times the training and experience was relied upon by this expert, and that expert's Nick Balance. And if he's going to be a testifying expert, the discovery rules allow for us to have their training. We asked for it specific to this Gladiator because we know that's going to be a big part of his testimony. So we're asking the court to order that we receive his training and certification records relating to the GAR product. Similarly, now we'll talk about the GAR unit itself and its calibration records or its certificates that it's in compliance. the court just heard the testimony from Mr. Ray about how important that is, that often they get tired, things go wrong with them, and they get restored to service. We do have 2 certificates, but what we need is what Mr. Ray called the bookends, so we need the other side. We know that it came in non-compliant and then it was restored and went back out. We don't know what happened after it was used, and we don't know the next bit of calibration that it went through. We don't know how it checked out. So we need the full copy, the bookend copy of the calibration reports.
But this is still in 2250.
That one is 250, yes. Sorry, Judge, I think that might have been in 251. That wasn't 251. 250 is the training records for the agents, and 251 is for the calibration records for the instrument. I apologize for that. 258 is a request for all information, all data, including all expert reports that the state has relied upon in developing the affidavits in support of all warrants.
But that's like a big one.
It's a big one, and the state responded with an answer saying, these are things that have been relied on. I'll tell you what my concern is, that there are things maybe in computer files, things on somebody's desk that haven't been turned over yet. So I think the court ought to order that the state make sure they've given us everything that was relied on for every single one of the warrants. Ms. Massa indicated to the court, and I know that other members, I think Mr. Logston has indicated that we're going to have motions to suppress. And so we want to make sure that we have all of the information. Possibly it would answer questions so we don't have to have this many. But
So we don't have to what?
have quite as many motions to suppress.
Okay, thank you.
That's not a promise.
I understand.
All right, Judge, let's talk about the 5th motion to compel. That completed the 4th. The 5th motion to compel, we are not going to talk about the 15th request for discovery until this afternoon. So my comments will relate to the supplemental request for discovery, number 12, number 13, and number 14.
12, 13, 14.
Yes. In request number 259, number 260, 261, 262, and 265, the state has let us know that these are coming. They responded on May 10th and said these are coming. They don't have a problem. So we're asking the court to order them to be disclosed to us. I think these are some that aren't going to be available for a while, but I think the court ought to order it. The state doesn't seem to have an objection to us having them. The order will mean we don't have to come back if something doesn't get through to us.
Okay, can you give me those numbers again, please?
Yes, I can. It's number 259, number 260, number 261, 262, and 265.
Thank you.
Your Honor, 289 related to communications between Detective Payne and the WSU officer talking about why to launch risks. I believe that that's been covered. Payne testified today that we have the instant messages and there was only a phone call and that was it. So to the extent that that's the very end of it, then we're fine. And so I think we are on that one. Item number 299 is called a tips lead sheet. And that's something that's referenced during the course of in the discovery. We were asked for an example that was sent to the state. I'm just going to ask the court to order that be disclosed to us. Number 300 relates to emails, notes, and other communications. The state's responded with 3 separate AV files, and I'm going to ask the court just to order that they all be given to us. We may have them all, but I'm going to ask that the court just order that just to be sure that we have them. Well, Your Honor, I take that back. I spoke with Ms. Jennings and I know there's one area, I'm not gonna talk about the area, but I know there's still one area that we don't have, so I'm gonna ask the court to order that all emails, notes, and communications be produced to us. Your Honor, the next item is the CAS certification and training for Nick Balance. And for many of the same reasons that we asked for that for the Gladiator, we need to have his training records. He's going to come in as an expert. The discovery rules cover this. You can see an example of him testifying as an expert in the transcript that I provided.
That's not covered by 250.
250 is the training related to the Gladiator specifically. This one is relating very specifically to his trainings for his CAS work and certification for his CAS work.
I'm sorry, but then what was the number for that? That training?
I do not think
That's 300.
that one's not 300. Let me find that one. I didn't write that number down. Give me 263. Co-counsel saved the day.
263.
And 264, I believe, relates to Sean Kennedy. Yeah. He's another FBI person. And I am now at still. Your Honor, items 274, 275, and 278 have been provided. Item 287 relates to a new expert, a blood spatter expert that the state is working with. We're told that that's going to be available in June. It doesn't seem that there's an objection. Would ask the court to order that be provided to us once received by the state. Request 289 we have. We're now at the 13th supplemental request for discovery. And that one is 302, item 302. That's similar to several others. So I'm going to hold the argument on that for a minute. I'm going to let the court know that items 303, 304, 305 have been provided.
Hey, real quick, I'm going to pop over. I want to listen to the verdict real quick. Is everybody okay with that? I want to listen to the verdict in Daybell.
Wonder what this is going to be.
I can always come back to the other one on Law and Crime if needed, because I know I was watching it on the judge's stream, and so I mean, she's just like literally going through the same fucking thing over and over again. And it's like, I get it. I get her frustration because she has asked for these items for a year, but they have the same answer. This is FBI information. We don't have it.
We're on the record on case CR 22-21-1623, right. State of Idaho versus Chad Guy Daybell. The court's been advised that the jury has reached a verdict. The court will note the parties are present. The state's present with Mr. Wood, Ms. Blake, Mr. Wixom, and Ms. Beatty. Mr. Pryor's here representing the defendant, Mr. Daybell. And the court at this time is going to instruct the jurors to please be brought into the courtroom. That will include our alternate jurors as well to be seated. And then I will have the marshal get the verdict form from the jury once they return to the courtroom. So if they can come in at this time, we'll have them brought in.
All right, please.
Yeah, me too, Sleuthy. If it comes out, if this is anything but guilty on all counts, I mean, but they don't do sentencing right away, so he'll have a sentencing hearing later, after a couple weeks.
Thank you. Please be seated.
But bum, bum, bum.
All right, the court's going to next just make a reference that there is a courtroom conduct order in effect in this proceeding to remain in effect. So I appreciate everyone complying with that order, as most of you have done throughout the proceedings in this case. At this time, then, the first matter I'd like to take up is to do a roll call of the jury for the record. So, Madam Clerk, if you could please conduct a roll call of our jury to make sure they're all present and properly seated at this time.
Juror number 1, red card number 27. Juror number 2, red card number 219. Juror number 4, red card number 631. Juror number 5, red card number 653. Juror number 7, red card number 752. Juror number 8, red card 1680. Juror number 9, red card number 823. Juror number 10, red card 1358. Juror number 11, red card 1365. Juror number 12, red card 716. Juror number 14, red card 997. And juror number 15, red card 1078.
All right. Thank you, Madam Clerk, for conducting the roll call. All right, at this time, I'm next going to inquire from the jury foreperson. Has the jury reached a verdict? All right, thank you. Mr. Bailiff, if you would please retrieve the verdict from the jury foreperson.
Chad, nervous? Are you a little nervous, Chad?
Thank you.
The heavens will open up and rescue him any moment.
All right, the court has reviewed the verdict form. I'll note that all counts have been properly marked, as well as the verdict form's been properly dated and signed by the foreperson. The next step then is Mr. Daybell, if you and counsel would please rise. I'm going to have the clerk read the verdict.
In the District Court of the 7th Judicial District of the State of Idaho and in for the County of Fremont. State of Idaho plaintiff versus Chad Guy Daybell defendant, case number CR 22211623. Verdict. We, the jury, duly impaneled and sworn to try the above entitled action for our verdict, unanimously answer the questions submitted to us as follows. Question number 1. In regards to count 1 of the amended indictment, is Chad Guy Daybell not guilty or guilty of conspiracy to commit first-degree murder of Tylee Ryan and grand theft by deception? Guilty. Question number 2. In regards to count 2 of the amended indictment, is Chad Guy Daybell not guilty or guilty of first-degree murder of Tylee Ryan? Guilty. Question number 3. In regards to count 3 of the amended indictment, is Chad Guy Daybell not guilty or guilty of conspiracy to commit first-degree murder of Joshua Jackson Vallow and grand theft by deception? Guilty. Question number 4. In regards to count 4 of the amended indictment, is Chad Guy Daybell not guilty or guilty of first-degree murder of Joshua Jackson Vallow? Guilty. Question number 5. In regards to count 5 of the amended indictment, is Chad Guy Daybell not guilty or guilty of conspiracy to commit first-degree murder of Tamara Tammy Daybell? Guilty. Question number 6. In regards to count 6 of the amended indictment, is Chad Guy Daybell not guilty or guilty of first-degree murder of Tammy Daybell? Guilty. Question number 7. In regards to count 7 of the amended indictment, is Chad Guy Daybell not guilty or guilty of insurance fraud? Guilty. Question number 8. In regards to count 8 of the amended indictment, in regards to count 9 of the amended indictment, is Chad Guy Daybell not guilty or guilty of insurance fraud? Guilty. Dated this 30th day of May, 2024, and signed by the presiding juror.
All right, Madam Clerk, thank you for reading the verdict. At this time, I'm just going to collectively ask the jurors, all of you, is this in fact your unanimous verdict on each of those counts? Very well. At this time, I'm going to inquire if the parties wish to have the jury polled. Does the state wish to have the jury polled?
No, Your Honor. Thank you.
Does the defense, Mr. Pryor, wish to have the jury polled?
No, Your Honor. Thank you.
Oh, interesting.
Very well, then. I'm going to direct the clerk to record the verdict. At this time, then, this does conclude the guilt phase of this trial. Because the defendant has been convicted on counts of first-degree murder and conspiracy to commit first-degree murder, the state has filed a notice of intent to seek the death penalty, and so a second phase of this trial, called the sentencing phase, will be taking place next. We're going to take a recess at this time for approximately an hour. We will come back on the record and begin with the start of that sentencing phase of the trial. I'd like to remind everyone that this courtroom conduct order is still in application throughout these proceedings. Thank you all for complying with that. We are going to take that recess at this time. Mr. Daybell is to remain in custody at this time for the commencement of the sentencing phase. And with that, thank you all, and we will be in recess.
Oh, so it is different.
All right, please.
They do it right away because of the death penalty part. Oh, I guess I didn't realize that. I thought they would still do it after, but Ariel called that one. Thank you. Well, damn.
I'd just like to say, I called it, guys. I had this very nuanced opinion that I think maybe this guy was guilty, and I just wanted you all to know
that you were
right.
You were right. You were right. This is the example that I typically use on. You don't see like groups with that are like, you know, pro support Chad Daybell or Chad Daybell's innocent, or most people just agree, and we all just sat back and waited for the process to take its course. There wasn't like a lot of fighting. Well, there wasn't a lot of fighting about it. I think the biggest fights that happened that I ever saw was whether like Chad was the mastermind or Lori was the mastermind. But nobody really ever disagreed on the fact that these were just trash can human beings.
Yeah, I have a 3-case parlay with Daybell guilty, BK innocent, and Richard Allen innocent. So I'm still alive.
Well, we'll see what you end up with there. The other two you're probably not going to see till next year, though.
Yeah, probably.
Okay, so sentencing for that is in an hour. Let me go back over. Here. I don't even know. Now maybe I can just speed it up if it's still on his live.
15,691.
Don't exist. These are videotapes that have been collected in the course of this investigation. You heard Detective Payne say that when he looked at cameras on South 95 and the other road south of Moscow on the date in question, and in conformance with what he alleged in his affidavit of probable cause to arrest Brian, he looked at those videos and he didn't find a car. That screams stuff that's exculpatory to me. I need to know where these videos are.
If it's too
They were
fast,
collected.
just
We're
let me
going to
know.
see that from the reports that we put in the packet of evidence. The court knows they've been collected, but nobody can tell me where they are. And I need to have I don't physically have time to go watch thousands of hours in Moscow Police Department and be efficient with the case. But if that's what I have to do, I guess I need the court to tell me that's what I have to do. I think you have the ability to order that there be an accounting of all of these videos. Keep in mind, what we heard today was exculpatory. So there has to be a duty to categorize all of these videos and give that information to me. Go find these videos that other police officers turned over to Moscow Police Department that are in relevant areas. That's just critical, and that needs to happen.
So I did look at a long list of videos that were provided to the defense that said there was nothing there, or the camera was broken, or so there was some kind of inventory there. And you saw that, right?
Yes,
Yes.
yes.
Okay. So what you want now is just a complete inventory of all of the videos that they obtained.
That would be appropriate to have that, but there are specifically named videos in the fifth motion to compel that we specifically want the videos. We know they're there. We've read the police report.
Okay,
We've given them a copy.
if it's 317 through, I don't know, 324, you're saying that those are specific
There's a
videos that you want, that you think you know are in this inventory.
Well, I don't know if they're in that inventory. I don't have them. I know they were collected and given to Moscow Police Department. I want to know where they are. And we listed out in 317, in 322, 319, 320, 321, 323, and 324 different locations that say we collected these. We gave them to Moscow Police Department. That's what I need to know. Where are they?
You didn't get any of these videos of this list that you just gave me.
No, of that list I gave you, I did not. There was also one that I asked to be included. I'm coming back to that number. It's 302. We did get a time frame on the day before the incident. And so I need to know where the time frame after the incident is.
Okay.
Okay. Thank you. Thank you, Judge, for that. I'm close to being done. Number 325. The answer was that if there was communications, it would have been a call. So that one's fine. We're good with that one. Number 326 is Uber logs between Detective Mallory and the Uber company. They've been provided to us, but I can't get into them. They're password protected. Miss Jennings and I have been trying to work that out. I think she'll continue to try to help me, but to the extent that it doesn't work, I'll need a copy that does work in some form. 336. 336 has to do with records, and I believe that Miss Jennings has provided or is providing a police report that will indicate these records don't exist based on an interview that was done. So we don't need to do anything with that one today. And I think the rest of them, 335, 336, 337, 338, and 339, the state has indicated that we've been given everything there is and nothing else exists. This all has to do with vehicle identification, and we're talking about identifying a car in question from a video as being a 2011 to 13 long truck. They say we have it all. So if we have it all, that's great. I just don't want any surprises. Again, Your Honor, and we think the court should order the things as we outline. They are material to the preparation of our defense. I would remind the court that relevance is a standard of whether it gets in front of the jury, but it's a different standard when we're talking about materiality. That was talked about in the Pendleton case, and I know the court's familiar with the Pendleton case. The court wrote about that in a previous order.
Yes.
So I'll leave it at that and just request that the court order these things. So
that list at the end about the identification of the vehicle, you're saying that they have provided that to you, but they're telling you that's all they have.
Yes, there are specific items that they say, we gave you everything that's there. The rest of these items don't exist. It has to do with cameras and camera angles and different things like that. It's spelled out in the fifth motion to compel.
Okay.
I just don't want to be surprised.
You just want to make sure that if they find something else, they provide some supplemental response.
Well, I'd be concerned if they find something else after they said nothing
Well,
else exists.
they're shaking their heads right now, but you never know. So, okay. Thank you very much.
Thank you, Judge.
Ms. Jennings,
Thank you, Judge.
there's a lot of stuff there.
Yes, and I'll try to make this quick. I'm not going to go through each of these items that are still out there for discussion, but just to give you a little bit of perspective of what all has been provided to date. The state.
Well, I rest assured, both sides, that I have gone through page after page after page after page. So yeah, I understand. I have some perspective about what's been going on and how hard both sides have been working. So
And just to give a little context, why this isn't just so simple. To date, we've given 15,691 bait stamped pages of discovery. So for a little context, this is too much binder. It would be about 39 of these. We've given 13,758 bait stamped photographs. That's about 34 of those binders of photographs. We've given 911 AV dumps. Those are digital files, in addition to a massive hard drive, about 50 terabytes full of discovery. And that includes audio video from about 285 interviews, 15,000 video clips from approximately 79 businesses, 8,000 video clips from approximately 10 residences, 417 files containing call detail records, multiple terabytes of records for 11 computer devices, 17 cell phones, multiple social media accounts, and 4 tower dumps. Excuse me, Ms. James, 4 tower dumps. In addition to records regarding well over 17,000 tips. We've given multiple terabytes of records in response to the 71 grand jury subpoenas, as well as the 101 search warrants that were done in this case. We have facilitated the defense viewing the physical evidence on multiple occasions, as well as facilitated additional DNA trace evidence to be examined at their request. We've had a consistent pattern of loading up discovery and providing a hard drive to the defense on an almost weekly basis. And just to be clear, we're going to continue to do that. As we receive discovery, we review it, we load it on our hard drive, and we give it over. Now, going specifically through each of the requests, we've already dealt with it in the fourth motion to compel. Item 214, we've already argued. Item 219 was already complied with. The CASVIZ laws. You heard the testimony, and what we know and what the judge heard testimony for is that CASVIZ is just a software program that allows investigators to put in like the records received from a cell phone provider like AT&T into a software program and they kind of visualize. Detective Mallory testified he got the raw data set from AT&T, used the default settings for the times in question. It produced a map. He took a screenshot of that map. We provided that screenshot. He only did this in response to our request to provide a visual for the grand jury. We've been told that optional session files were not created or saved, and that this item simply doesn't exist. In the current version of CASVIZ, the user settings are automatically saved in an exported session, but instead it just returns to default settings. I asked Detective Mallory about this. He advised us that he used the default settings. It doesn't take much time or effort to redo this, which is why he didn't save those logs. That's his normal practice. He just saved the screenshots and we provided that. We agree, we will double check. We're doing that throughout all of this. To our knowledge, there are not tower documents that were relied upon, but we will double check and inquire, and if that exists, then we will turn it over. 226 has to do, well, first the request was for the AT&T Hemisphere program, and then it detailed several other things below it. And we were told they didn't use the Hemisphere program. And you're right, language is important as to exactly what's being requested. And now after a series of back and forth, they're saying that they want AT&T timing report. We have been told if that's referring to timing advance records, those records don't exist. We do have these location records, the DBOR records, and we've given those over. Now the second part, it says that investigators recently obtained certified records from AT&T, and that will be disclosed in upcoming discovery production. My understanding is that that's not related to the above. It's not related to Brian Koberger's records. It's related to other records that were done later for other folks, but we will be providing that in the next production book. Next is 228, complete copy of all materials relied upon Corporal Payne. To our knowledge, we've turned all of that over. We have given the documentation of correspondence between our CAST agent Balance as well as with Detective Payne, and he testified today that the only other communication, they were together. So they were just relaying things verbally, and that he was including that information in his report.
Can you give me the numbers too? Because I'm trying to keep track.
I am on 228.
Thank you.
229 has been complied with. Now we're at 242, our complete CAST report. We've already discussed that.
When you say complied with, does that mean that both sides agree that it was complied with? Or is it that you saying that you complied with that, but they are still asking for it? I just want, speaking of language.
Well, I can't speak for the defense, but to our knowledge, we have provided everything that relates to the metadata.
Okay. I just want to be clear about that. So if both sides agree that this is done, we don't need to keep arguing about this. But if the state is saying, well, we've complied, but they don't agree with that, then that's something I have to deal with. Ms. Taylor.
Right, there's so much here. So the clarification on this is they did give us MAID data. I've been working with our expert and we think that all the data is there, but part 2 of it has to do with the Babel information that's coming. That's in the 5th motion to compel. And
That's a great
good one to remember. Yeah.
Yes.
And so I need that to put those 2 together. So I think the MAID data we have, I need to reserve though and say once our experts have full time to look at the MAID data, once we get the Babel stuff as well, then we may have a problem. But they did do a disclosure. For sure they did do a disclosure. I just can't say it's all of what we were looking for quite yet.
All right. So some of these we might come back to me to say, okay, where there's something missing or everything's fine.
And I will speak with Ms. Jensen if I notice that ahead of time too.
Okay, thank you.
243 relates to the final draft of the CAST report. 244 is done. 248, there's still some questions about. I will say that Ms. Taylor reached out to me last week, letting me know that they believe there might be some missing pieces there. I reached out to SA Balance, asking, he was at a training all last week. I've been told he's looking into it to see if there is additional information, then of course we would produce that. That's all I know at this point. 249 is related to the above. 250 to the state relief that's been done. And 258, again, this is a very broad request. If there's something specifically that they're looking for, that would be helpful. But as far as the state's concerned, we've complied with this request. We've given you the returns for all of the 101 search warrants that were done, as well as the affidavits, which detail exactly what the investigator relied upon in order to obtain those search warrants. Again, if there is something specific that they're seeking or looking for, if they can provide that to us, then we will inquire. Now we move on to the 5th. Items 259 through, well, 259, 260, 261, 262, and 265. Yes, our answer is that we have inquired. We've been told that this is coming. The employee responsible for these items is out on medical leave for about 6 to 8 weeks. We still have probably another month left before she returns. And then we need time for that to be completed. But we do intend on giving this over. As we've done already, as we get it, we turn it over. Item 289, this is completed. 299, temp lead sheets. State has provided information for well over 17,000 tips in this case. We've been advised by the FBI that they believe they provided all information related to this. Now, I'm unsure if there are duplicates of the same information. We will inquire, but substantively, it's our understanding that they have all the information for the 17,000 tips. But yes, I will inquire and see if there's something, a tip lead sheet that can be easily provided. 300. This has, for the majority, already been provided. They already have the ISP and PD emails. I've talked to Ms. Taylor about another certain section of emails that she would like to see. I will inquire about that, and if they exist, we will turn them over. 263 and 264 have to do with CAS certification and training records. I can tell the court we're going to comply with this. We're not at our expert discovery disclosure deadline, and we're just not at that point, but we will be. And we plan on giving this over on anything we intend to rely upon. 274, 275, 278 have all been done. 287, this is an expert analysis. We haven't received it. We are expecting to receive it sometime in the next month. As soon as we receive that, we will discover. 289 is done. And starting with 302 is when we get into all these different surveillance videos. We have provided them a list of all the videos as they're labeled and as they're stored at NPD. Now, yes, we will do our due diligence to make sure that what we have is turned over. To date, though, and we'll continue to do that. To date, we have located a Watson Carey construction video, but the only thing we've located is one that covers from about 9 p.m. on the 12th till midnight. We'll continue to look for what they've requested. And as soon as, if it's located, we will turn it over. 303 has been completed, 304 has been completed, and 305. The next series, 306, 307, 308, 309 are all part of the 2-week process. As detailed in our response, we've been told by the FBI that it's going through their process. And we're hoping to hear something back about whether or not these are approved and when they're going to be provided in early June. 313 is done, 314 is done, 315 is part of, again, the 2-week process, as well as 316. Again, we should know more early June. Back to videos, 317. The first thing they asked for is this US Bank video. That's been provided. Ampersand, to our knowledge, it doesn't exist. Again, we'll do our due diligence to make sure. If it's located, we'll provide it. One World Cafe does not exist. And 9 to 5 is actually US Bank, and that's been provided. Red Star Coffee, we have, and 319, 320, 321 are all ones that are still outstanding. We'll continue to try to locate those. If they exist, we'll turn them over. 324, 325, 326 have all been complied with. 334 does not exist, and there will be a supplemental report to that effect. 335, 336, 337, 338, 339, 340 have all been complied with, and that gets us to the end of the 5th for this hearing.
Thank you. Any response?
Your Honor, just really briefly, I want to talk about item 226, the Hemisphere program. Ms. Jennings asked me if we meant the timing advance program. That's one and the same. I just heard her say that those records don't exist. I just need to be clear, if they don't exist, then I need to know that. If they do exist and they were used, I need to have them. She mentioned that item 250, that's the balance training records that we have, that we don't have that. That's balance training records related to the use of the Gladiator machine. We don't have those. 251 is partially complied with. That's the certificate on whether the Gladiator machine was working appropriately. We need the follow-up the next time that machine was put back for testing. Both machines, there were two. 263 and 264, Balance and Kennedy's past training records. I'm happy to hear that I'm going to get those. With regard to the videos on exhibit RR that the court has under number 21, this is where the business said they already had given over their videos, and Ampersand and One World Cafe are both listed on that as well. So they were given to somebody to go to Moscow Police Department at some point in time. And that's it for clarifications for me. Thank you.
Great, excellent. Anything else?
No.
Okay, great. All right, a lot of work there.
Great.
For all of
Get the
you.
hell out of my courtroom.
But why don't we take a break? And we're supposed to start the second chapter here. Why don't we start at 2:00? That's okay. All right.
Not even a half hour.
So we'll recess. Thank you.
It's not enough time.
That's literally enough time for him to go have a scotch, and that's about it.
Yeah, I could see that.
He's like, that's all I need for lunch. All right, so that's done. And then the second part's closed because it's on the IGG, which is, to me, probably one of the most interesting pieces of this case, because I love investigative genetic genealogy.
Yeah, so what are your thoughts about it being in the PCA? But it sounds like the FBI was the one who did the IGG.
They did. Absolutely. So here's kind of where I'm at with, I think I've summed up this entire thing to, they are particularly trying to prove, there's obviously some things that they think are missing with the video and the reporting, but what Ann Taylor is essentially trying to get to, and you guys can think I'm totally wrong, and that's fine. This is what I kind of just surmised from everything we just heard. Ann Taylor wants the state to admit that the IGG is anything and everything from them, that they had nothing else, and they take this trace DNA from the knife sheath, they get the IGG done, and then everything comes after that. That's essentially what I think that she wants them to admit to, and they refuse to admit to it.
Yeah,
and so everything else goes with that. Everything else is to prove, like, if you were, like, the whole thing we were talking about earlier with the whole, whether they were doing these pen registers or however they were tracking him, how did you even do that? And why did you do that? If you're saying you didn't know who he was, then how did you get there? But if you're already tracking him, so then they're trying to backdate it, like, oh, no. We got, that guy gave us a tip from Washington and from Pullman, and that's how we started doing things. And we got it off this phone data, but essentially everything is from the IGG. They find his name, they match it to this cell phone, they match it to this tip with the guy from Pullman who says he owns this white Elantra. And so her defense is going to be, they took all these pieces and made them fit because of the IGG, and then she wants to show how the IGG is flawed and get rid of it.
But so who made so the FBI didn't indict him, and these were reports and evidence generated from the federal investigative grand jury, and they can't turn them over or cross-examine any of the evidence in the state trial. because the FBI is not going to engage. They haven't so far.
Correct.
Do you think they're going to actually use the IGG? Because it sounded like the prosecutor today said that that wasn't going to come into trial.
So the prosecutor, so essentially when it comes to IGG, there's no legal standard. There's no legal definitions behind it yet. It's so new in the scheme of the legalities behind it that it's typically referred to as a tip. And I know people are like, it's not a tip, it's science, but it's typically referred to as a tip because there is no legal standards with it. Some states have started to put their own legal standards, but there's no, like, we need an overall federal standard of how it can be used. So what they're doing is saying like, hey, you know, we got this tip saying it was Brian Kohberger. Like somebody calls in and says, hey, I know it's Brian Kohberger. And then they go and they start doing all of these things to figure out if it's Brian Kohberger, which is the investigation, which is what the prosecution is saying here is, no, you know, we're not using that to determine he's the guy. We did this entire investigation to prove he's the guy. Look, we got the cell phone. We were doing this drive around thing and we were looking for the cell phone towers and we got all this data. And then we track him back to Pennsylvania where we go and take his trash, which is legal. Once it's in the trash, we go take the trash, we run it, we put it in CODIS and it matches as a, you know, as a father to our suspect. And then, you know, we're doing all this surveillance for what, 3 days, I think it was, maybe 2 or 3 days before that. And then they go arrest him. So she wants to show they would not have ever gotten to Brian Kohberger if they hadn't done this IGG. And so she wants to show that the FBI did it incorrectly. It's the same thing from her hearings before is, so there's still standards of practice, you know, or best practices when it comes to IGG. And she's trying to say that they went against those best practices. And when I go through like the IGG stuff here, the problem is there's no legal best practices. There's website policies. So for instance, Ancestry, you know, that's probably one of the most popular ones that, you know, people use for, you know, genetic testing. You are not legally allowed to, or I shouldn't say not legally, you are not, see, I just screwed that up myself. You are not, according to Ancestry, allowed to upload data that would be used for a criminal investigation. So, but that's against their policies and procedures. It's not an illegal thing to do. And she wants it to be an illegal thing to do. You only can use these specific sites. So she thinks that the FBI was cutting corners, which is why then she holds or has asked Judge to hold this in-camera hearing where he goes through and reviews all of the IGG stuff. And then he makes the determination on what he wants to give out based on that these are anonymous people, the people who are the relatives. So if my third cousin put their information into GEDmatch, that person is an anonymous tip. Like I can't go and call that person out. They're an anonymous tip. That's what they've chosen to do. That's what they've signed up for. So she wanted all of that out. And the IGG hearing they're having this afternoon is because it was ruled on after the in-camera hearing that he was only going to give them parts of it, and they weren't going to be able to share those names or that particular information he allowed, which we don't even know exactly what he allowed. They weren't even going to be able to share it with their investigators on the team because they don't want it out.
Right.
So now she's like, hey, I need you to let me like share this info. But like I said, after everything I heard today, my feeling is she is trying to show that everything they did was after the IGG result and the IGG is bad. Hence, nothing they did would count. It's almost like fruit of the poisonous tree without actually being fruit.
So I can see that definitely being a strategy that's going to play out in the future. I think right now, well, her argument is it's going to get to that. But right now, I think she's arguing that they cannot cross-examine the validity of this because the FBI is the one who confirmed it. And they do not have any ability to call the FBI or look at the documents that they used. And they don't know when the IGG reports actually came back. I think that's what they were talking about with the subpoenas. I think there were some federal grand jury subpoenas that were issued in coordination with the IGG results that would show that maybe they had the IGG information on a different time. Because as of right now, as far as I know, the day the IGG match came back, it's not public.
I believe it's the 19th.
And so is that from an actual? So that's from a filing, the 19th.
No, I haven't looked at filings for quite a long time. Just in my mind. Oh, Sleuthy, where is it from that it's the 19th?
Yeah, I know it's in her timeline on the 19th too. So
I believe it's the 19th. And that's why I'm like, I don't sort. I'm gonna have to. What is it from? What do you remember?
But that's when it may have been put into a state filing. But if they had a sealed federal or a federal grand jury, we may never know when it actually was.
But did the federal grand jury accomplish anything?
It seems like they're using a lot of the subpoena. She said that they had 79 subpoenas or search warrants that were issued in conjunction with the federal grand jury. The prosecutor said that today.
Yeah, what's the federal grand jury to look into what?
The murder, I guess. It's as a task force investigative grand jury for he didn't get indicted and it's been sealed. So yeah.
But that's just the state grand jury.
No. That she was talking about the federal and state grand jury today, the prosecutor.
Yeah, I know, but I don't understand. The state grand jury had already indicted him. So what are they even convening to do?
Well, people think that, we don't know this, but people think the federal grand jury was first. Yeah, Ariel says that they think that.
I understand that. I just don't understand to investigate what. That's kind of where I'm at. Like, what is the federal grand jury going to do? He's indicted on the state grand jury, but that's why Phoebe just said, like, he thinks that some people suggest it's actually from before.
Yeah, and they never went through with the indictment, but they used all that evidence for the PCA, but then they're saying they're not going to present any of that at trial. And so I think Ann Taylor's trying to get around. She's trying to make these motions now for this issue. And it's not necessarily a federal issue. It's just that they use the federal grand jury for the subpoenas to gather information as a task force together, which just happens quite a bit. Like the TUI processes, it can be very frustrating for defendants, especially indigent defendants that can't pierce the TUI process because it allows task forces. We may see this in Delphi too. It allows task forces to hide behind the federal sovereign immunity to have some of that information that would normally be cross-examinable not be able to come in at trial, where they just have to say, I relied on my training from the CAS team, and they may not be that sure what the actual process itself entails.
So why would the federal grand jury be looking at anything?
We don't know. But we do know that this does happen and that is sealed. And
it's because he lived in Washington, the crimes are in Idaho, and he's arrested in Pennsylvania?
Well, I think that given that amount of the 4 people that were killed being college students, being from all different areas in the United States, they believe there is some type of interstate nexus that could be involved in anybody that would want to kill all 4 of them. And yes, they were also just working on the case as well, but they presented it to the federal grand jury because they don't have to. They can get better subpoena authority and search warrant authority, and then the FBI has the ability to charge time to the case because they would anyways, but like they have a little bit more ability to use their resources because it's their actual subpoenas and search warrants they're working on.
Okay, so you think the federal grand jury was actually convened before because they were such a influential part of the investigation?
Well, that's what most people that I think like Andrea Burkhart, who's an attorney from Washington State
Yeah.
that covers the
Yeah, she's
case.
great.
She has said that. Some other people that are familiar with the federal process, Travis is really familiar with the federal process too. He could probably give us an explanation next time he's on. But yeah, I think that most people that are aware of that process think that that grand jury did happen beforehand, and either they failed to indict him, or they didn't
Right.
seek an indictment, and they used all the information from the federal grand jury to build the PCA. And that's why Payne and Marcie are saying, oh, they just told me this stuff. I was co-located. They just said it to me, because they don't want to have to provide the actual reports that were used, because they could hide behind TUI and they would have to fight it out for that. They can just say, well, they told me this, and he's testifying to what the lead was or whatever. So it's just, yeah, it's a process that's really designed to help the state and the federal government to help the state prosecute people with state charges, and it can be debilitating for somebody who doesn't have the resources to fight it.
Okay. So Ariel's like, well, I know they have all that power. I was just curious on why this would be a federal grand jury to begin with. Like, that doesn't make sense to me. But I get it. I kind of get it, I should say.
Yeah. So like in the Delphi case, there's a FBI case file report. It's a kidnapping case. And right now they've charged him with state kidnapping charges, but the FBI did have a case file open for potentially they could have investigated federal kidnapping charges of a minor if they feel like there was an interstate nexus to it. But they're in it. Maybe they could end up taking it federally completely, or just having it go back through the state process, but having the subpoenas up front is just another layer of power, I guess you could say.
Yeah, I guess for me, if there was a federal grand jury that was brought in before there was a state grand jury, to me they were trying to charge him federally. Like, that's where I can't get past that in my mind, that they were trying to tie something to him in a federal case and they weren't able to, so they went to the state grand jury. That's where I'm at with it. I don't know how to get my mind to not think that.
Yeah, and in that situation, there really is no they. Like, there's no one person making a decision.
Right.
So it would be the U.S. Attorney's Office.
The equivocal or unequivocal they.
Right. So
them.
It would be the U.S. Attorney in that district that can make the federal charging decision, and it could also be that the prosecutor said, let's try it to see if we can get an indictment federally first, but it doesn't necessarily have to even be them seeking an indictment. It could just be an investigative tool, which is strange. It's not how we normally, because they're usually sealed. So like, even if that was the case in normal another murder case, we would maybe not know about it, but because of the profile of this and the quality of representation he's getting, and the state backing off and trying to point towards another entity as the reason why discovery is not getting turned over, we are kind of learning more about the federal process here.
Okay, that makes sense. Okay, makes sense.
Who knows though?
Yeah, I don't like this is that's a new one for me in this case. I guess I didn't, wherever that started at, I never caught that.
I think it was the CIA, honestly, so it's whatever. Figure it out. But on the really quick, I wanted to go through a quick little thing here. She said something about the car, the video of the car, right? Oh my God, there's a Trump verdict?
No way. Is there really?
Well, they won't show it the courtroom, but
no. I don't know. I was reading something on the Trump stuff, and I don't follow it. I hate the political parts of it. It just actually gets under my skin. So I just kind of like try to surface cover it, or like follow it. But I was reading something, I think it was yesterday, that the jury was saying that they didn't get any jury instructions. I was like, I got to look into that.
I heard that they were talking about the Secret Service being in jail with him. Oh my God.
They're guarding him at the jail. Oh,
No, they
God.
said that they would literally be in the jail cell with him.
They stayed in there.
No, like he wasn't. He got booked, right? Like,
Yeah.
but like, if he were to get convicted and have to get incarcerated, like the Secret Service is prepping to potentially have to do time with him because
He's the president.
Yeah, he's the president. He still gets protection no matter what.
Yeah.
It's crazy. I don't know if that's actually going to happen, but
Oh, they're like, this is a new one. All right.
Right.
I don't know. A verdict reaching the trial. I'll have to look at that on Twitter later.
yeah, well, that's probably another CIA out there too, you know.
Yeah. See, you just brought up the CIA, and then it's like, look, verdict reached in the Trump case.
Yeah, so just pulling the levers over here.
Okay, go. What were you go?
Yeah,
with
so
what you were going to talk about. Sorry,
Yeah, on
interrupted
the
you.
no problem. The exculpatory issue with the vehicle, I think that's really interesting because, like, if you think about, we know that they don't have to turn everything over, right? But if they have a video nearby the scene, maybe if it's even 5 to 10 minutes away, but it is a route back to Pullman, and the vehicle isn't in that video, is it possible that that is considered exculpatory? Because right now we know that state's theory is that he won west, right? But
Right.
say that his alibi is that he went south or was in the southern area down there instead of the northern area at night with whatever we figure out about these cell tower pings. But him not being in a video that they have, her argument is that the mere existence of a video without his vehicle in it is exculpatory and they should turn it over.
I don't agree with that.
I think they don't agree with it either, the prosecutor.
Well, I think maybe I do. Maybe I would agree with it. I would agree with it if the videos they're turning over don't have his car either.
Well, what if it has a white Elantra?
Right. Or don't have a white Elantra. Let's say the videos that they turn over and they're like, okay, they don't have the white Elantra, then why aren't you turning over the other ones that don't have a white Elantra?
Well, what if it had a white Elantra? Oh, of course, yes, I see. But what if it had a white Elantra, but they said it was not exculpatory because of the cell tower pings were showing that he was actually, north and closer to that cell tower, but the drive test doesn't actually pan out to corroborate that. Then is it exculpatory?
The drive test doesn't corroborate the fact that he went north, and then is that what you're saying?
Yeah, like say that they only said that was exculpatory because he went a different direction, and that wouldn't have pertained to their theory of the case. If they made that decision based on evidence that doesn't actually come in, would that then be exculpatory because they can't explain why they decided that it wasn't exculpatory?
It kind of makes sense. Because
Yeah, so-
I would go back to they don't have the right to determine if it's not exculpatory if they don't know the value of the evidence to begin with.
Right.
So then it would become potentially exculpatory.
Yeah, I see Ariel here says they remember seeing an Othram IgG testing date. There is a rumor about that. I don't know if that is in a filing, but I think that would be the 19th date. But
that might be where it's coming from. That sounds very familiar.
But there is a theory out there on that, that when you have a mutual agreement with a private company as a public agency, that you pay in like a 90-day like a 90-day settlement for all the services used the previous 90 days. I'm sure some of you guys do this professionally as an accountant or something and knows what I'm talking about. But that 19th, I think the defense requested to get more information about that to see if that was actually the date for one single service, or was it like a continuation of multiple services over the last 6 months or so.
You think it was like an end date?
Well, I mean, it could be just they pay every 90 days, and just because that was kind of right around that time, and it was public information, that people thought that that was the date that that report came back and they got charged for it and paid for it. But I don't know if any of you guys ever try to get money from the federal government or the state government. They usually don't pay the same day.
No, it's true. Well, I also wonder. Well, I don't know, because it makes sense. It makes sense that they would go and get all these warrants on the 23rd then.
Yeah. Or well, unless they kind of were going through that federal process for a couple weeks and then decided that they were done with it. I mean, just because I agree, the closer it is to that date, it does seem more like boom, 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 like we got it now. And the timeline that's out there, I think that I've been looking at from Sleuthy, that makes that pretty clear. Like if there's not like guaranteed information that it came back earlier, it coming back on the 19th and then having all those surveillance warrants and stuff like that makes it seem pretty sure to me that it was back on the 19th. But
it's definitely right around there.
Yeah,
that's my opinion.
And the thing is, like what she's saying is, like, if we don't have the dates for these subpoenas, all 70 some of these subpoenas that were issued, how do we know about the timeline? Because if they say they issued a subpoena to Othram, right, but it wasn't a state subpoena and it's sealed, and it was issued in December 1st, something crazy like that, right?
Mm-hmm.
Don't you think that information would be really important for the defense to know?
Well, if it's a subpoena to like Othram, do I think it's important for the defense to know? Because no, it's not being used in the trial. This is a point of contention, I think, for a lot of people, is that if that's how they got him, then it should be used, but it can't be used because there's no legal standing on what can and can't be used of it.
Yeah. And I think they're concerned about, there's some concern. I know some people are not going to want to hear this, but there has been concerns about Othram using people that have opted out. And some people agree with that. Some people don't. It's kind of controversial.
Right. So Othram doesn't build the tree in this case. The FBI actually requests for them to send the data back, and then the FBI builds the tree. They don't even, like, Othram starts and then they're like, no, we're going to go ahead and take it from here. So the FBI ends up actually being the one to connect all the people.
Okay.
And that's one of the concerns, though, just like you said, is that the FBI is doing things not on the up and up. Once again, it's not to a legal standard. It's just to a policy and procedure standard of what these websites say. Best practices.
Yeah. So it's unclear in this case, but I know in previous cases, there's been, allegations that they used opted out profiles. And I think the argument there would be that the people were not fully aware. I mean, you sign the giant list of things that you're signing away, right? But if there is an explicit thing that says that it's not going to be used for law enforcement, and law enforcement isn't notifying the JetMatch or or Ancestry.com that they're using it, they're creating a profile for law enforcement purposes, then I think that's where people have issues. They should identify that they're, because you could just create a profile and put your DNA, any DNA on there. And
so, like, for Ancestry, for instance, you can't upload raw DNA. You have to actually have, like, you can't like upload the raw data. You have to actually have DNA to submit. And then you can say, so let's say you were going to try to submit my DNA without telling anybody it was mine, and you just put it in as it was DB's DNA. And then you get all these results back and you build this tree. Nobody knows that I'm this perpetrator that you're actually using, right? Because you just put in whatever information you wanted to. They have to have enough DNA to be able to actually do that with a company like Ancestry. Now, other websites that opt out of law enforcement, you can take your raw DNA. So Ancestry, you can download your raw DNA and upload it to other websites. So that, like, if you and I are brother and sister, but you tested on Heritage and I tested on Ancestry, we're never going to find each other. But I can take my raw DNA and stick it over on Heritage and then find out that you're my brother, right?
Right, which we found out a couple weeks ago, but that's cool.
Well, I'm just telling the world now. So,
I happen to think that even though that's the public, that's what everyone understands of it. I do think that the FBI, just like they do with Apple and Google, there's probably a backdoor.
Of course. But
But
it's not illegal. It's not an illegal backdoor.
right, but if you can't cross-examine it,
Nobody's going to use it. Nobody's going to direct examine it
Right.
for it to be cross-examined. And that's what the prosecution's point is like, hey, we're not putting any of these people on the stand. We're not using any of that. We're essentially saying we got a tip, we followed up on the tip, and this is the investigation that resulted in the arrest of your client. And she's saying, no, I want the tip, and I want to be able to research how you guys got the tip and how the tip came in and how you did everything with the tip. And they're like, no, we're not giving you that.
right. But if they use the PCA to arrest him, that's no longer that they're no longer supporting. Their question is whether or not the arrest is valid, and not even just under the fruit of the poisonous tree doctrine, but like the probable cause itself. Did they actually lack probable cause at the time? Not was there an omission or something that would be like able to be thrown out on a Frank's, which I think they're filing a Frank's. I think they said so. More Franks, more better.
I can't do it. No way. Well, still problematic though is because in the warrants they're saying not to use the DNA in the determination of whether the warrant is approved. Essentially, they're saying yes, we have this, but essentially don't count on it as anything. Count on everything else we're telling you, but we don't want to keep that we have it.
Okay.
So the judge signs off on it. That's where I'm like, this is the problem, is this is so uncharted territory. And this, I said this like when I covered the case all the time. What happens with the IGG and what he rules will be setting a lot of precedents in future legal cases in Idaho for sure. And if not federally, because like I said, there's only a couple states that actually have any legal standard.
Yeah. Well, if they say that it was in the PCA and it's an omission because they didn't explain it fully or something, or it was a material misrepresentation, I just don't know how that's going to play out. I see both sides of the argument for sure, but like I said, I lean defense side usually.
I know you do.
So I'm a communist. I'm a freaking commie.
Great. Oh, my brother's a commie. That's all I needed.
Well, go ahead. Sorry.
No, you're good. Go ahead.
I was just gonna say one of the last things. There was a lot of technical information in there, and it kind of got off the rails with the pen testing thing or the pen register thing. But basically, it just sounds kind of like the same thing that's going on with the IGG, is that they don't have the ability to cross-examine it, and if it's not going to be used at trial, then you could just arrest somebody under different pretenses that you're going to use for trial, and then that evidence, even though the judge says it meets the probable cause standard, it may lack the foundation of it being usable or like being enough to convict somebody at trial, that the initial PCA. And that's why they made that argument to the Supreme Court about the federal or the state grand jury standards. And a lot of people thought it was strange, but about whether it was a probable cause standard or beyond a reasonable doubt standard. And I think there's going to be more that helps us understand where they were coming from with that. But and then they talked about the timing advance and the hemisphere program. That's a little bit like the Stingray mobile cell site tool. It's more of an intelligence tool. If you guys do want to learn more about that, it is really interesting. So
I think I've heard about the Stingray. That sounds very familiar.
Yeah, that's more of an intelligence tool usually, but they have been using it for like anti-terrorism stuff.
That might be why I know about it.
Oh, there you go.
Okay, so I was going to say something. I don't remember what it was now. Shit.
Uh-oh.
That's old age. All right. Well, I'm going to wrap it up anyway. I got to go pick up kids from school. This has been very interesting testimony from Ray, from Cy Ray. I don't know if I understand everything he was talking about, but I will say I don't know if it was a fair comparison to put these two guys who have literally like a day of training on anything cast and then put it up against the expert when truly it's going to come to the FBI guy Balance, who is the one who's really behind the scenes as the puppet master of everything to do with these reports against Cy. You know what I mean? Like, I think
If he
those
comes
two,
and testifies.
if he comes and testifies, right? I mean, that's because these two guys are they're chumps. They don't know what the hell they're doing. He's saying like, I'm counting on, like Payne's going, I counted on Maury, and Maury's testifying like, I know everything I know from the 2-day training I took in 2019.
Yep, and he says he's not even the main guy in his own police department for it.
Right.
Crazy.
Oh, Trump verdict in like 5 seconds. Okay. Oh gosh. Oh, hold on. Fluffy Bunny already said counts 1, 2, 3 guilty.
No way.
This is so ridiculous. I don't want to get too far into politics because then it'll cause more debate.
That was enough. I think everyone got the idea there, T.
Well, I think whether you like him or not, this is still bullshit, and that's where I go with it. So,
okay,
that's where I'm at.
Hey, well, thanks for having me.
No, I can't thank you enough for coming up and dumbing down what the hell I was like. This is like I felt like I was in a different world, and I'm like, this is not my forte. You know, I felt like we were talking about guns.
Yeah, we could talk. I didn't do a very good job in the beginning. I given some more notes. Job. I can. Oh, thanks. I can. Guilty in all 34 charges. Oh no. Okay. Well, hey guys, I gotta catch a flight. You know what I mean?
Jeez.
I'm out.
Thank you, DB. I appreciate it. All right, everybody. Thank you guys for hanging out here and watching the Brian Koberger hearing and the verdict in the Chad Daybell case that happened to pop up right when we were in the middle of going through that hearing. The beginning of the hearing was definitely way more interesting than the end. I'm sure if I sat down and went through each piece that she was talking about, that I could piece it all together. I just feel like we've done this like 7 times now, and the common answer is that's the FBI and that's the TUI process, and we don't have it. So I don't know. I don't even know if I would want to spend my time doing that. I'd much rather, if they are going to do a Franks, we'll definitely cover that because that would just be crazy. But I don't typically cover a lot of the BK court filings because, like I said, they're so flippin' repetitive. I will be back in about an hour and 5-ish minutes, and we will be doing Karen Reed, going back to opening statements, and then hopefully Scotty Skulls is going to come up, and he wanted to talk some about the dash cams, and he had some things he wanted to add. So, like I said, I appreciate you guys. I know that there was a lot of places streaming the hearing today, and yet you guys chose to come and hang out here with me and DB, who apparently I let run the channel because I just take myself off the screen. But I'll be back in a little over an hour. So if you're interested in Karen Reed, get back here in a little bit. I'll talk to you guys later.
Do you dare to follow me down? Head into the unknown. Down the rabbit hole. Where it stops, no one knows. We're going Do you dare to follow me down? Head into into the unknown.